friends.
Hi, friends.
We have a QB with us today. Hi, QB.
Hi.
We were just hanging out in the background, just chit-chatting and
Chitter chatter.
chipper-chapper. I still have a bit of a sore throat this morning, but so I feel better than I did last night, but I still got that like raw little tickle. And I have my cough drops. These are the not sponsored by Young Living. However, these are my cough drops. They're very strong.
Do you have a tissue to spit it out if you need to?
I've got a sticky piece of release paper that I can like some labels that I can lay it on so I can use it again here in a moment. But I promise I won't drop it in my printer.
Yeah, Lisa, keep it out of the printer.
Yes.
Where is everybody?
I don't know.
Hi.
Hey, Henny, good to see you. QB came in with all the things. All the things QB came in with. Make sure when you pop in that you hit that thumbs up button. Make sure to like and subscribe. Share with your friends. Hashtag replay in the comment section down below if you're watching this on the replay. And we do have memberships available here at the Crime Cafe.
Tell your friends.
Tell your friends. All right. So last night, as I was getting ready to go to bed, and I did take NyQuil last night.
Hey,
and
Patricia.
I slept really good. Hey, Patricia. I slept really good last night, but I took NyQuil. But before I dozed off, I was sitting there scrolling around. And you guys, if you're not following the docket on Twitter, you got to go follow that.
Yeah.
I'm going to drop his link here because shout out to the docket.
For facts.
I just put his link there in the chat too. He's got YouTube too. But his name is on Twitter is like Chasing Paper, but he goes by the docket. So he came out with these motions for Ashley Benefield from her. She's looking for a new trial.
And y'all, she might get it.
She might very well get it.
It's crazy.
If what is being alleged really happened, she may very well get a new trial.
I don't know, Jenny. He was pretty specific. Like, it was like uber specific to not be. And I mean, we all know that he kind of exaggerates sometimes. But, that stuff in there was specifics.
Okay. I want to know after you guys hear this, okay? I want to know if you think that Mr. Clean was the one, or Mr. Clean's grandpa is the one who came up with this, or did Tiny Table Man 2.0 come up with this?
Tiny Table Man totally came up with this because it's social media stuff. So Tiny Table Man 2.0 saw the stuff on social media and was like, hold up, let me compare times. And he was comparing times and he was like, yo, these are very specific.
There are two different instances going on with these juror potential misconduct. Okay. Right. We have one juror who may potentially have brought a flip phone into the jury deliberation room and may have allegedly been texting her brother who was in the court, or no, not in the courtroom, but in the Law and Crime Network chat.
Yep.
Typing as things were coming about.
Like on the second, like it was like, we're going to have a verdict. And he was like, we're going to have a verdict.
Yeah.
Like, it was, apparently we need to pay closer attention to the toxicity that is the Law and Crime Network. Oh, Patricia, you have no clue. It's so bad.
There's another bit of maybe misconduct where another juror may have allegedly lied on their voir dire jury fill out paper and questions
The question
about past
not only past, like, criminal
activity.
history, but it's a DV history on both sides, against her and towards her. Like, it's bad, y'all. Yo, it's
Yeah, and
bad.
this was a DV case.
That's what I'm saying. It wasn't even like just criminal stuff. It's like DV. It's bad. Y'all,
Yeah,
she
I
might
mean,
get in trouble.
they always wanna know from the jury, the potential jury, if they have issues or have had issues in the past themselves personally that is similar or any way, shape, or form similar to what's the trial is concerned about, what the trial is concerning.
Yeah. And they'll
I
ask
mean
you, like, past criminal history because they wanna know if you're gonna be, like, pro cop or against cop or whatever, but then they
Mhm,
ask specifically, do you have any history of DV or SA or whatever the case may be?
mhm.
And if what just, I meant to go on, the meds kicked in. I meant to go on and search um, her history. Ooh, I'm sorry. Did you hear that?
Yeah, that's okay, it wasn't loud.
Bro. Um, I meant to go search her criminal record. I mean, I can't, again, he was very specific
Mhm.
on the the instances that he quoted,
The actual charges.
the charge, yeah, and like what actually happened. So I'm just saying, like, I think Tiny Table Guy 2.0 like totally hooked him up.
Well, and I
And
think that there's evidence to prove the issues with juror number 15
yeah,
because, um, he says, like, exhibits are include which they're not included
with what we have, but
with what we have, but they included exhibits to different charge numbers, case numbers, dates, names even.
hashtag Tiny Table Guy 2.0 needs his law degree.
He does. He really does.
He really does.
Mhm.
Dude should pay him to get his law degree.
Yeah.
But I don't know, and here's the thing, y'all. I keep ever since this case has been this case bugged me. This case bugged me a lot. I had a really
Mhm.
hard time with this case because on the one hand, I know I feel deep within my soul that he was probably not a good man.
Mhm.
Not deserve to die, man, because
Look at the
we don't
little icon.
where is the fact that you figured out to do that is freaking hysterical. When Margaret comes in, she's gonna freak out. When
She will.
I kid you not, when I saw Baby Boss, I almost choked on my drink because I didn't see it at first. I didn't see it, and then all of a
That
sudden I
one?
saw it. Yes, that one, and I was like, I am deceased.
Mhm.
I am deceased. But yeah, so I had a hard time not believing her, but then I had a hard time believing her.
Yeah.
Um, I think that I think that they need to work around their defense in a way that it doesn't require her to get on the stand because she's not believable. She's
No,
not
and to be
believable.
fair well, but now wait a minute. I have to say, I would have voted her guilty until she got on the stand. When she got on
She
the stand, then I would have said reasonable
maybe,
doubt, but there were some things that she did, like the lack of tears. I mean,
yeah.
that
And
chick is dehydrated as all get
hey,
out,
Jenny.
right? Oh, hey, Jenny Trioli. Hi.
Yeah. So, um, yeah. I mean, And I mean, again, there are people in trauma. I don't know. It was hard for me. And what was really hard for me, what was really, really hard for me was the way that the prosecution went at her.
Mhm. Yeah.
Because for me, well, one, it was triggering, but two, it was it made me very angry because it made me feel like now people who would come forward. um oh, Truth Revealed, I love Truth Revealed, Jenny. um
That sounds familiar.
he's the guy that he's kind of like, okay, so you have Never a Truer Word, which is Jack. And then you have Truth Revealed, I can't remember his name, it's like Sergio, I think. So Jack does actual, like, he does words. He does. Oh, I think they both do words, but they have different methods.
Hmm.
Um, yeah, he analyzed her testimony and he found her truthful. Now, there's some question
Wow.
as to there's people that argue that his method, which it's not his method, it's a method used, it's a government, I mean, the government uses it, everybody uses it, that his method might be off.
Mhm.
But I don't know, I find his stuff to be pretty. I mean, like, he did a whole thing on Brian Higgins. And so what he does is he analyzes patterns in the
Mhm.
beginning to
Yeah,
see,
okay, I know this guy. I
you
remember
know what I'm
seeing
talking
him. I
about?
went and looked him up, and yeah, I've watched him
Yeah,
a few times, yeah.
he's pretty good. So he analyzes patterns, um, truth and not, and then he's got like the trigger things, like when they say, instead of saying don't, they say do not. He's
Mhm.
like, that's a tell.
Yeah,
When they switch from the present, I think the behavioral panel does it too, says that too. When you switch from the present to the past, or the past to the present,
yeah.
when you're talking about past stuff, but you speak in the present. Um, when you repeat phrases, like when you're like, I told him to go down the hill. Do you know what I'm saying? Like stuff like that. It's pretty cool. It's pretty cool. But yeah, he analyzed her and he found her to be truthful.
Hmm.
So I think, I don't know. I had a hard time with it. I had a hard time with it.
Yeah. They say he uses the read technique, but I think the bad part of that is in questioning, like, not analyzing.
Yeah. Yeah, the read technique has had some controversy behind it. But it makes sense though. And if you start to, like, if you look at the patterns that he talks about and then you start like analyzing your own stuff, like what you do, not that
Mhm.
we lie or anything like that, but like there's even tells, like, not necessarily that you're lying, but that the subject that you're speaking about is very sensitive. Like
Okay.
there's sensitivity around it. So you might be lying or it may just really bother you. Do you know what I mean? And
Yeah.
so yeah, he's very cool. I like him, and I like Jack too. It's, I think it's called Never a Truer Word. Um, yeah, yeah, that's that's what I've heard. But I think, okay, so I think, Jenny, and I could be wrong, so I don't want to say like absolutely, but I think what happens is they use the read technique to review their, or to analyze their questioning, and then they determine that they're lying, and then they go hard on them
Oh,
under
yeah.
under the premise that they're lying, and then they end up getting a false confession. I don't know that that's the case, but I feel like that's what I've read. Yeah, Jack is very cool. Jack is very cool. You should look him up, Jenny. It's never. I think it's Never a Truer Word.
Okay, I think I've seen him before too.
He's on with Jay and Bob a lot.
Okay. I think I've seen this guy too. I mean,
Yeah,
I tend to find things anytime there's any, like, analysis or
yeah,
whatever sort of, like, behavior or speech, whatever, I'm always like, "Ooh, let me watch that." I love
yeah.
that.
I love the behavior panel.
Mhm. They're one of my faves.
I love them. Well, because the cool thing about them is that they're all 4 different. They have different ways of analyzing stuff,
Right,
and then
right.
they discuss it, and it's very cool.
I like to watch them, like, bounce things back and forth, you know?
Jenny, I was just gonna say that. I could listen to Jack talk all day long. I think is he New Zealand? Is it New Zealand? I think it's New Zealand. It might be Australia, but I think it's New Zealand.
Well, let's get into because I wanna get through these motions. QB's gonna do some reading for us today.
Yay.
I, I wanna get through this, though, and, then we're gonna start another stream and resume the TELUS trial.
Which 2 questions. Hey Sherry,
Hey,
which
Sherry.
one do you want me to do first, and do you want me to share my screen?
You can go ahead and share your screen if you want. Um,
It's not redacted. I mean, I can scoot
I
past
know.
it real fast, but I mean, I don't think that their names. I don't think that I didn't see an order anywhere. Um, and I mean,
Yeah,
he
it's
didn't
not
redact it.
redacted. It's not redacted on Twitter. He didn't redact it when he shared it, so I'm talking
Okay.
about the docket again.
Yeah.
Um, here, hold on. I'm gonna drop his, link
Can you
again.
can you pin it? I don't know how to do
Yeah,
that.
let me do that real quick. Um,
Is that out of YouTube?
mm, oh, you
Out?
know what? It is because I can't.
I think it's out of YouTube.
But I'll do that.
It's just easier than having
Mhm.
to
Get out and go into StreamYard, or I mean YouTube,
yeah.
but yeah, there you go. It's, the docket on YouTube, and then you can find him on the docket or Chasing Paper 89 on Twitter, so. But
And Jenny and I were just
I I was just gonna say I would love to start with the motion to interview jurors
the jurors.
first,
That's what I thought.
'cause that's the best, that's the
That's the
juiciest.
juicy one.
Yeah. So
Okay, so let me I'm just trying not to dox myself. Let me check all my little
you have to watch it because every once in a while, whenever like when I opened these, there was a little pop-up that came up on the right-hand corner that
Mhm.
was like
I had
your
yeah.
Google
I've
thing.
gone through them all, and I think that I have it set correctly. So let's see. Share screen.
Oh, by the way, I had pumpkin spice creamer in my coffee today.
I have. Did I tell you about the brown butter cookie?
You did, and I
Girl,
saw that, it's on rollback at my Walmart.
it's so good. And I bought it, and Jay saw it, and Jay was like, Jay likes to put creamer in his milk. Like, so it's like chocolate milk,
Yeah.
but it's creamer milk, like it's flavored.
Mhm.
I don't know. I mm.
I mean, I picked up my whole, like, Walmart grocery list or my Walmart pickup yesterday, and, Jolie was not having the refresher thing from Dunkin's, the kiwi strawberry or kiwi watermelon refresher. She was like,
Ew,
"No, mm-mm."
ew. I'm with her.
It was really yummy. It was good.
Was it Melanie or was it watermelon?
No, it was watermelon.
Okay, because
Yeah,
there's a
because I
difference.
can't do, like, cantaloupe or
Uh-uh.
honeydew,
No. That's why
but
around here I don't have cookout, right?
no.
Okay, so that they have like they're cheap, they have great hamburgers, all that stuff, but their milkshakes are like the crap. I mean, they're so good. And they have a watermelon milkshake during July and August. And I told Jay, I'm like, I want to try it, but if it's Melanie, I'm gonna be big mad.
Mm, yeah, this isn't. It's actually really good. Um, but what I was gonna say is that, um I was looking to make sure I didn't see anything good. Okay. I think
I
it's good.
triple checked it 14 times.
Okay. But, so whenever I got to the Walmart pickup, the guy's putting all the groceries and stuff in the back of the van, and he's like, is there anything? Because I had one of those, like, rotisserie chickens from the deli,
Mhm.
He's like, "Do you want this up front?" Because they always ask that. Because sometimes if they turn over, the juice runs out, but anyway, I was like, "No, the only thing I need is," because I had bought Jolie some strawberry and chocolate Yoo-hoo drinks for school lunches and stuff, in the little box cartons. And she was dying of thirst, and I'm like, "Just give me the strawberry Yoo-hoo." So that's the only thing she was interested in. I told you she's a milk drinker. That's about all she'll drink is milk.
Jenny, I like fake watermelon when it comes to like Jolly Rancher fake watermelon.
Mm.
I do like the Jolly Rancher.
I love watermelon flavored stuff, and I love lime
Lime is
flavored
my
watermelon.
jam.
I love lime.
I'll put lime on lime. Like
Mhm.
I love me some lime.
I do too.
I found some Sonic limeade water flavoring.
Mm.
It's so well, I used to have one. Great Value used to have one. It was a limeade, and they quit making it. See, peach. Okay. Oh, peach is a conundrum for me because sometimes it has like a weird aftertaste, and I'm not a fan.
Yeah, I'm not a fan either.
Oh, Laffy Taffy banana.
That's yummy.
The $1.25 tree has bags. The whole bag is banana.
Yeah, I know, that's pretty cool.
Yeah, so peach, I like peach, the peach tea, the water flavor, peach tea water flavor, I like it. I like peach knee high. Peach knee high is the jam. Anyways, sorry. Ooh, peach Jolly Ranchers. See that flavor I like, but when they try to do like a real peach flavor, but it's not a peach, it has a weird aftertaste to me. I don't like
Mm.
it. All right.
Sorry, excuse me.
All right, is it moving? Do you see it moving?
No.
What the what? Why isn't I'm sharing it? Why isn't it moving? Hold on. Let me try it again. Sorry.
You're good.
Motion to interview. Okay, I don't know. Chrome tab, window, entire screen. Share. It's not moving?
Now it's moving. Yeah, now it
Okay,
is.
cool. Okay. All right. You ready?
Yes, ma'am. Let's do this.
Go. All right. Hang on a second. I can't watch chat, so
Okay, I'll keep an eye on it.
motion to interview jurors. This was okay, so there's some confusion. It was filed on August 9th, which was a Friday, and it was after 5. So it looks like Manatee County, it says filed at Manatee County Clerk on 8/14 at 5:15. So I'm not quite sure what happened there. Also, this right here is the dude. they linked his whole YouTube. This is
Mhm.
the dude that they're saying that the sister was on the jury and had the flip phone.
Mhm.
Okay.
Hey, Mary Lou. Hi.
Hi, Mary Lou. I'm just gonna depend on you to say hi, and then I'll say hi.
Okay.
Oh, you know what? I can see chat. It's on my TV. Shut up. I can't open it on my phone because if I do, then I get the reverb and it's bad. Okay. Motion to interview jurors. Ashley C. Benefield, by and through undersigned counsel and pursuant to that rule of the Florida Rules of Criminal Procedure, in conjunction with and as a part of her motion for a new trial, hereby moves the court to conduct interviews of the jurors in the instant matter. As grounds in support of the requested relief, Ms. Banfield submits as follows. 1. On July 30th, 2024, the jury rendered its verdict. 2. Evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. This alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair trial and impartial jury and subjects the verdict to legal challenge. 3.
Here we go. This is where it gets juicy.
Look, y'all, and look, Taylor had no problem. He called these people out and then put it in all caps. Okay, he was like, "Y'all messed up." All right. 3. During jury deliberations, a YouTuber user, that hoodie guy, posted comments on the Law and Crime Network's YouTube live stream of the verdict watch. These comments contain real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. 4. The comments posted on July 30th, 2024 reveal A. At 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, the hoodie guy posted a comment stating verdict incoming. Exhibit A1. And there's no exhibits. We don't have exhibits. I can try to find them, or maybe Googly can find them. I don't know. Where is this? Is this in Florida? No. Where is she? She is in Florida. She's in Florida, right?
I can't remember.
If she's in Florida, we might be able to find the exhibits. At 10:25 p.m., that hoodie guy, bro, you need a posted a comment stating, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. Exhibit A2. At 10:27 p.m., that hoodie guy posted a comment stating, my sister snuck a flip phone in.
Oh. Snuck a whole flip phone in.
He's not too bright.
So this hoodie guy, I've looked his account up. He's not a YouTuber. He's just got a YouTube. I mean, like everybody else has a YouTube account.
Yeah, and see, so here's the interesting thing. Like I turn off the chat if I'm on law. I'm very rarely on Law and Crime. I'm usually watching it through someone else. Thanks, Jenny. I thought it was Florida. And so I'm very rarely watching it through Law and Crime because, anyways, so their chat is super, super toxic. And also, people just throw things up like out of the blue, like, and they have no bearing. I mean, they have no information. They're just like, so I heard that there's 2 jurors wearing a red shirt, and everybody goes, oh, are they wearing red shirts? Really? But this stuff is specific, like, and on point for the time.
Right.
Like, he's like, there's a verdict incoming, and then boom, verdict incoming. Like, and if he was, I mean, he might need to be a psychic. If he wasn't right. So, okay, sorry. Okay, wait a minute, sorry. Okay, I read that. E. At 10:28 p.m., that hoodie guy posted a comment stating, my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter.
So,
sorry,
I'm sorry. No. I'm not. There was. It just blows me away because, like you were saying, just any Joe Blow can type in the Law and Crime Network chat. There's 50 million people in there. The chat goes so fast, right?
Morgana.
Hey, Morgana. So the chat moves so fast, and people say all kinds of things. You know, you can't, you don't know what's
You can't
true,
trust
what's
nothing.
not.
You cannot trust a dang thing in there.
But, you know, I mean, if this is true, because like it says here in a minute, the timing and specificity of these comments, blah, blah, blah. So
It's
it's
too
kind of
close.
pretty valid almost, you know?
So, but here's the thing. Okay, so we're gonna go with Tiny Table Guy 2.0 probably did this.
Mm.
So did Tiny Table Guy 2.0, did he go back and like review the 50 million comments, or do they have somebody watching the 50? Like I could be a comment watcher. Like anybody, if y'all are
Mhm.
listening, if there's any law firms out there that want me to be a comment watcher, I would totally do that.
25 doc 25 bucks an hour. I'm kidding. I'm kidding.
Cash money. Under Oh, we can't do that. No, never mind. I didn't say that. We'll talk. Anyways, like
Huh?
how did they? I don't know. Like just because we all know that Mr. Taylor ain't on the social media. Okay, he didn't
Mhm.
even. Well, that was the judge. He and the judge were both like, I don't know. It's out there on something called YouTube, maybe or something. Like, oh, honey, I hate that chat. I do not, and I don't use hate very often. That chat is toxic AF, and there's no moderation at all. None.
Nope.
Um, and Morgana, did you hear me go, Morgana? Um, yeah, Hoodie Guy
Morgana.
clearly needed some attention. Unfortunately, he's about to get the bad kind.
He gonna be
Because, like,
hauled in.
I was
Well,
gonna
I
say,
mean,
but ain't that like jury tampering or something? Like, can't he be called in for that too?
I don't know that he could, because he's not the one that took an oath to not say nothing, you know what I mean? It's all
True
her on his sister, the juror.
story. Well, I mean, he must not like his sister very much because he threw her all up under the bus.
Yeah, but he probably also had no clue. You know, most people don't know the whole jury. I mean, they hear it, but they don't know. And then how old is it? Maybe he's like 17 years old. Who knows? I don't
Well,
know.
he may thought, he may have thought the likelihood that they would see it in all that chat
Yeah.
would be, I don't know, but somebody, we got to give Tiny Table Guy 2.0 a little more credit, I think.
He needs to get his law degree and get in there so he can afford some bougie sweat rags.
He does. Bless his heart. I'm not going to disparage him for sweating because I sweat like a man and I
Me
can't help it
too. Me
because
too.
my thyroid is broke and maybe he needs some thyroid help. I don't know. But God bless him because he was hot.
Mhm.
In a suit hot.
Mhm.
So there was a judge. Who was the judge? Oh, it was on Charlie Adelson. He had a sweat rag.
Oh yeah.
Yeah. Anyways, okay. Number 5. At 10:30 p.m., a mere 2 minutes after the hoodie guy posted that the jury may compromise on manslaughter, the jury returned a compromise verdict of manslaughter. Sorry. Also, so he was hot and not in a good way. So the other thing is like if he didn't have an insider, how would he know they were going to compromise on manslaughter?
I don't
Like
know unless he's a, what do they call him? A seer?
that's what I said. Is psychic. He better go buy some lottery tickets, find some missing
Call me
people.
now.
Call me
Call me
now.
now.
Use your powers for good, man. Go find some missing people. Don't be messing
Oh.
this up. So yeah, so like because remember when we were watching it, we were all like, "They gonna come back hung. They gonna come back hung," because they were hung.
Mhm.
Anyways, okay, number 6. The timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that the hoodie guy's information originated from within the jury room during active deliberations. This presents a breach of the jury's sworn duty and impacts the fairness of these proceedings, subjecting the verdict to legal challenge. They were hung and not in a good way,
Oh
Morgana.
my Lord, Morgana's killing
Morgana,
it in here.
I knew somebody was going to say that. I would buy some sweat rag merch. Give me a little microfiber cloth. I would buy it.
Right.
7. This alleged misconduct raises serious concerns about the integrity of the jury deliberations and the reliability of the verdict. Specifically, it raises questions about a juror, a flip phone, no doubt, a juror smuggling an electronic device into deliberations, which is not permitted in the jury room. B, real-time communication of a confidential jury. Real-time communication of confidential jury deliberations with non-jury members. C, influences external. What? Influences external to the evidence presented during the trial may have influenced the verdict. D, access to the unauthorized materials affect the verdict. E, the overall integrity of the fact-finding process being compromised. 8, the prompt removal of these comments. Oh, yeah. Did you see this part, Jenny? The prompt removal of these comments from the Verdict Watch on the Law and Crime Network's YouTube channel live stream further underscores the seriousness of this potential juror misconduct. So, like, they were there and then they were gone.
Yeah, I saw this part last night. I had to read it a couple times because I was like, wait, are they saying they were removed or I had to, like I said, I was NyQuil'd up last night. I had to read this motion like 3 times.
Yeah, the two of us were a whole pair because she was NyQuil'd up and I took pain meds, and we're both trying to read this. And then Jenny's like, I think it's a dude. And I was like, I thought it was a girl. And she's like, I don't know. I need to go back and read it. And then I was like, I might need to go back and read it. Y'all don't read legal documents on drugs. It's bad.
Drugs are bad.
Drugs are bad. Okay, so here's where so they totally removed the verdict. So here's the thing. If they removed it, somebody had to be in there live. Or somebody had to have gotten a screenshot or something.
Yeah, somebody's gotten a screenshot.
I need to know.
Or it could have been like moderators that are in there may have like I don't know. But somebody got it. Somebody got screenshots of it.
And I'm sorry, y'all. I tend to do this when I'm like talking and not reading, so I'm going to try not to do that. Bob has it set up so it goes right into the next page. I don't know how he does that because it's kind of hard to scroll. In addition to the above evidence, here we go, y'all. In addition to the above evidence, evidence has come to light indicating that the verdict may be subject to legal challenge due to jury number 15 called her out in all caps, being untruthful during voir dire by falsely representing that she had not been a victim of crime. Her son had been charged with a crime, and she had involvement in child custody, domestic violence, abuse matters. Y'all. Number 10, Juror 15 completed a jury questionnaire under the penalties of perjury, which asked, have you or a member of your immediate family been a victim of a crime? Juror 15 responded untruthfully to the question by admitting that she, 1, had been a victim of a crime, battery, touch, or strike domestic related, on February 20th, he got the deets. On February 20th, 2016, when her live-in boyfriend, Albert Ballinger, intentionally slapped her in the face with an open hand 5 times. And 2, that her son, Hayden Walcott, had been charged with a felony battery against his pregnant girlfriend on August 31st, 2014, for which Juror 15 was the bond depositor. Y'all. Hey, Margaret.
Hey, Margaret. Good morning. Morgana says, I'm on a roll. But
you are on a roll. Look, when what was I gonna say? He got deets, like deets. Like deep deets.
Yeah, oh yeah. He deep dove those deep deets.
I was just gonna say, I'm gonna look up this case number. I was just gonna say he did everything but give the case number. Lord have mercy, it's right there.
He gave the case number. Yeah, he had all the receipts. The receipts.
You see, Jenny, when I see when I do this, do you see that blue thing that pops up?
Yeah.
It says content is still loading. Please try again. It's been loading for 4 days. I don't understand.
Hmm.
I wonder if I had an account to do the things, if that would say, "Oh, it's loaded now."
Oh, I have no idea.
So she posted the bond for her son when he beat his pregnant girlfriend.
Mhm.
But wait, there's more. 11. On March 18th, 2016, Juror 15 filed a petition for injunction for protection against domestic violence against Mr. Ballinger in the 12th Judicial Circuit Court in and for Manatee County. That case number right there. The allegations of the latest act of violence or threat of violence provided that Mr. Ballinger grabbed Juror 15 by her hair and repeatedly hit her in the face, causing a black eye, damage to the inside of her mouth, and swollen face. A copy of the petition is attached here too. So at this point, I was thinking, why are they bringing her up and throwing her under the bus? Because she actually would be for the defense, right? At
Yeah.
this point, don't talk about what comes further. At this point right here, I mean, I can see why they would do it because they want a new trial. But I'm
Mhm.
just saying, why are you throwing this girl under the bus? Because theoretically, up to this point, she would be on their side, but there's more.
There, but there's more.
But there's more. Okay. 12. Juror 15 was a respondent in a petition for injunction for protection against domestic violence filed on September 2nd, 2003 by her ex-husband.
Yeah, pause. So, I wasn't sure what respondent meant, you know,
Right.
but it means she was the one that received this petition for
She's,
injunction for protection
right. She's basically the
against.
defendant
Yeah.
in that
So,
instance.
she had all
So
these things happen to her. Now we get into the bits and parts and pieces where she's the aggressor.
Patricia called out, Margaret, you see your prize at the top?
Allegedly.
Allegedly. Yeah. So he beat her upon her head and face, and then she turned around and beat him upon his head and face.
Not the
So
face
juror
and
15,
you say head and face, and we say face and eyes.
the eye holes. Um, so juror 15
Uh,
was a respondent in a petition for injunction for protection against domestic violence filed on September 2nd, 2003 by her ex-husband. And also, hold on, if memory serves me, hers was in 2006. So he filed on her
before.
before. Bruh. That just hit me. Bruh.
Mm.
By her ex-husband, Charles D. Walcott, seeking protection for himself and their minor child. Wait for it. In the 12th judicial. Oh, wait a minute. Let me see what the probable cause affidavit is attached here to it. I need to see
I'd
PCAs.
like to see the probable cause affidavit
I need
too.
to see PCAs. Where's the exhibits?
Mm.
In the 12th Circuit Court in and for Manatee County, case number. I'm going to pull up case numbers. Hang on a second. Let me. Well, no, I can't
Where's
write.
we could have if Googly was here, Googly could be looking up these case numbers and stuff, but
No, I'm gonna write them down, and then when we go to Robert Tellis,
mhm.
I'll look them up because Florida is a you can have all the things state.
Mhm.
2003 DR 4890,
BR
and
549.
you know,
I know. Junior Samples is your mom's cousin.
no, my grandma's.
Grandma's cousin. Well, it's your mom's cousin too. Well, would it be or is it your dad's? Never mind.
So y'all don't even want to get into that story. Sorry, excuse me. I'm scrolling back up because Sarah Yvonne. So it's Walcott versus Walcott, and what was her case number was? Yeah. Okay, wait a minute. 2016. So he filed in 2003, and she filed in 2016. Ma'am,
Mhm. Years
bro,
later, like 13 years later.
Bruh. Okay. So
Unless that's well, I mean, even if it was 2013 and not 2003, it would still be 3 years prior, so
Margaret said you need probable cause to be showing big eyes up there.
Mm.
Okay. Okay, seeking protection for himself and their minor child in the 12th Judicial Circuit Court in and for Manatee County, case number, a copy of Mr. Walcott's petition. I need a copy of the petition. The docket, if you're listening, sir or ma'am, whichever the case may be. I
It's
think
a
it's
sir, it's a sir.
okay, are y'all ready? Here we go. Juror 15 being threatening and violent, including cussing, slamming doors, threatening, and throwing his things at him. B. Requested that his son come and stay with him until Juror 15 can get some help. Juror 15 attempted suicide and was hospitalized on or about July 18th, 2003. She called and told Mr. Walcott that she was going to kill herself. They just outed this woman. Like, all
Put
her
all her
things.
business out there, I know it.
Well, she shouldn't have lied. She shouldn't have lied. C. Constant harassment and threats to his wife and himself.
Allegedly, because now
Allegedly. I don't know
yeah.
if they got. I need to see if it was disposed.
Well, I mean, he's got footnotes, he's got
I know. I'm gonna
case
look. I'm gonna be
numbers and
looking at
all of
footnotes.
that,
I'm gonna
but
be looking.
unless or until,
But for
these things are confirmed via a court hearing,
allegedly,
allegedly, alleganiously,
right?
you
Period.
know, yeah.
I told you about my shirt, right? It says allegedly. Period.
No, no.
I just noticed.
If you were Grace and you lived in Australia, it would say allegedly full stop.
But that's what the period is. So I didn't notice the period when I ordered it, and then when I got it, I was like, "Bro, it says allegedly." Period.
Does it have a T on the end of it?
Yes, I'm gonna put a little T. I'm gonna take a fabric marker and put T.
T-
Um, D. Fear that juror 15 might look, y'all. Fear that juror 15 might try to take his son's life along with hers the next time she tries to kill herself. Bro. E. Request to keep his son until juror 15 is well. Specifically, he requested supervised visitation until juror 15 showed that she was stable mentally and financially.
Oh, wait, Jenny Trielli says if he isn't saying alleged in the motion, likely they're disposed as true. An officer of the court won't put it out there as true if it isn't. I
Yeah.
get that. I'm just wanting to,
And at this point, it is either disposed. There's got to be a disposition.
Mhm.
Either way, I mean, it's been 20 years. There's got to be something. We're going to go looking for it. And by
I
we,
just
I
want to, protect
right,
my little
Allegheny
corner of
County,
the YouTube over here.
right? The little time, yeah. We're just yeah.
Yeah.
13. Juror 15 was also a respondent in another petition for injunction for protection against domestic violence,
A year
filed
later.
a year later by her ex-husband, seeking protection on behalf of their minor child in the 12th district in and for Manatee County. That case number, a copy of Mr. It's not attached here too.
But now make sure you write that down because that's a different case number.
Did girl, I done wrote it down.
All right.
Juror 15 picked up his son, ma'am. Juror 15 picked up his sons by the arms and slammed him against the wall.
I think that's what I read that made me think that juror 15 was a man.
Yeah.
The way I
'Cause you
read
was
that is what
swimming.
made me think, "Daggone, dude, what's wrong?" But it was the female that did that.
Right. The minor child, while visiting with Mrs. Walcott, expressed that he was afraid to go home. What?
I'm wondering if Ms. Walcott is maybe the dude's mom?
The wife, the wife, the wife, the wife.
Oh, the current wife. Yeah, because I forgot she did
Who had
also allegedly harass or something the wife,
the
right?
wife. Yeah. Oh, a report of child abuse filed with the Bradenton Police Department. I'm gonna need that report number. I can't get it. It's a minor child. Juror 15's boyfriend threatened to hunt Mr. Walcott down and kill him. They all a mess. Ongoing investigation by CPS. Mr. Walcott was seeking custody, and the minor child was showing signs of being violent. Yeah, because everybody's hitting everybody. 14. Juror 15's failure to reveal this information during voir dire amounts to juror misconduct and subjects the verdict to legal challenge, entitling Mrs. Benefield to a new trial. Y'all, she gonna
get a new trial.
She's gonna get a new trial, y'all.
You watching hide and seek.
I mean, you got the flip phone and you got the juror. She done. She getting a new trial. 15. This motion is filed with the 10-day period prescribed by that rule to address this urgent matter. Given the nature of the alleged misconduct, Ms. Benefield asserts that there is reason to believe that the verdict is subject to legal challenge on multiple grounds. A. Including but not limited to. A. Juror misconduct. B. Introduction of extraneous prejudicial information. C. Influences external to the evidence presented during the trial may have influenced the verdict. D. Violation of jury sequestration. I'm sorry, my mouth is not working. E. Violation of the defendant's 6th and 14th Amendment rights. F. Jurors potentially receiving evidence outside of the court proceedings to the detriment of the defendant's substantial rights.
Well, I mean, if the chick literally did, if the other juror, not juror number 15, but if the other juror,
the sister of the hoodie guy,
yeah, Lord, you don't think it's the same? That's not. Is there anything in there that's telling us that that's the same?
No, they indicated. I mean, they didn't indicate her juror number. It felt like
it was two different people.
Like it was a separate person.
Okay,
but check this out. All caps. All caps. He called them all out.
He did.
He don't know who. He don't know who did. He knows she did the thing, and then somebody else did the thing. Is that supposed
we don't know who the other somebody else is.
So here's all the names, and we didn't redact it because nobody else did. 17. The integrity. It's Florida. They let all them out. The integrity of the judicial process and Ms. Benefield's constitutional rights are at stake. This court has both the authority and the responsibility to invest this matter fully, including granting permission to interview all jurors who served on this case, to wit, all those people's names in caps. Wherefore, Ms. Benefield respectfully requests the court. Here's what's funny. Why do you file a request for acquittal and a request to interview jurors and then a motion to DQ the judge? Why are you going to try to make him angry before?
I don't know, but they were all filed on the same time.
At the same time. Not smart.
Yeah.
like keep that one on the DL until you get what you want. I don't know. Wherefore, Ms. Benefield respectfully requests the court, A, grant permission to interview all these jurors that are now not in all caps. B, expeditiously set a time and place for interviews to be conducted in the presence of the court and the parties. C, summons the juror to appear at the time and place set for interviews. D, grant any other relief this court deems just and proper under the circumstances. Mr. Taylor, i.e., Tiny Table Guide 2.0, certificate of service. Mr. Taylor is not Tiny Table Guide, but we know that Tiny Table Guide did this. Okay? Look at his bar number. Look at his bar number. His bar number is like, that might as well say number 1.
Right.
Because they're like in the 7 or 8s or 9s or 7 digits now.
Mm-hmm. Because he's old. He's an old man.
He is.
What?
Bro.
Oh, that's you. I was going to say, that sounds like my phone. I'll wait till she comes back because she's getting a phone call.
No, I'm not. Can you hear me?
Yeah.
No, I'm not. I thought I put it on D&D. I apologize.
That's okay.
And it's hooked to my computer. So even though I had it silenced, it rang in my computer. Sorry. So I'm gonna stop sharing that.
So I wanna know, aside from the other jurors, if none of those other jurors saw the one juror with the flip phone, they may not have any proof, nothing to prove that. Like, they could lie their way right out of that. He could be like, "I was playing. I was joking. I don't yeah, she's my sister, but she didn't." You know what I'm saying? Unless they pull his phone records and see that he's literally got messages coming to him saying
From a
that.
random flip phone? I don't know. I could see Tiny Table Guy 2.0 doing that though.
Oh, yeah. I could
Yeah.
too, but, like, that would be why they would interview the other jurors, is to see, did you see said juror with a flip phone?
So here's what's so funny. Are y'all seeing precedents being set? Because you have um Murdoch, okay? And they brought the jurors back and interviewed them.
Mhm.
Okay. This is not common practice. However, it's becoming very common practice because now they want to call Karen Reed jurors back,
Mhm.
and then they want to call these guys back. So
Mhm.
it's crazy. And also, did you see that the Supreme Court is going to look at Murdoch's stuff, the Court of Appeals?
I heard something about it, but I didn't know
Yeah,
what
they're
turned
gonna.
out.
They've said they'll review it, and he might also get a new trial. Just saying,
Mm.
I'd be here for it. And again,
I mean,
okay,
I would be here for it again because that was just epic. That was an epic trial. If
I
you've
didn't
not
watch that.
watched the Murdaugh trial,
I
it's
watched
epic.
it through Andy, which was fun. But
Yeah.
and it makes me sad that I can't talk to him about it. But
Mm-mm.
because he would be flipping out if he knew that they were going to give him a new trial because he was like, he did it, he did it, he did it, he did it.
Was it
Um,
Shiraz that came in here the other day and said she wasn't sure that he was guilty? Or was that
it
someone else?
it may have been, it may have been. Um, I would totally watch it. I have watched pieces parts. I've gone back and watched pieces parts because everybody, and I love that judge. What was that judge's name?
Mhm. I'm so bad with names. What was
Bring
his
the
name?
jury. Bring the jury. I can't remember his name, but
Margaret'll probably remember his name, but yeah, I
yeah,
liked him a lot. Newman.
Newman. Yes, Newman.
Okay. I
So
forget names
here's the
easily.
thing on him, on Murdoch. It's the same thing as Alec Baldwin. Okay.
Mhm.
Oh, Miss King. Hey, Miss King, how you
"Hey,
doing?
Miss King."
Uh, Patricia said the forethought for it to be a flip phone that they brought in is really damning. Don't they know burner phones only work if everyone has a burner phone? You ain't wrong. You ain't wrong.
Yeah, true.
Um, do you want to give Miss King a recap?
Yeah, and hey, Miss King. Hi. So basically, Miss King, there was a motion that QB just read, and I'll give you the recap, but if you want to rewind it later and watch it from the beginning, you're more than welcome to. However, what had happened was the defense filed a motion on Ashley Benefield's behalf stating that they want to interview jurors because there is allegedly um, some juror misconduct happening with two different jurors. One juror allegedly brought in a flip phone to deliberations and was talking with her brother, who was in the Law and Crime Network chat live stream
Giving all
and
the info.
putting out all this information about 5-1 manslaughter, blah, blah, blah. And then the second juror misconduct is there's a female juror number 15
Sarah.
who, yeah, answered um, no she answered no to, "Do you have any criminal background with DV, blah, blah, blah." I don't know what the actual question was, but she lied on her jury voir dire, and, she does and did indeed have, DV criminal DV charges against her, and She has been the aggressor and the aggressee. Is that how you wanna say that?
Yes.
She's had DV against her, and she's DV'd against others, so.
Including, but not limited to, her son
Yeah.
and
Ex-husband.
allegedly, and her ex-husband's new wife.
Yeah.
Hey,
But
Carol.
she lied about that.
She lied. I put the
And this
link.
was a DV case, so, you know, I mean, that's a big deal.
It's a whole hot mess. And he brought receipts and case numbers and details, and I don't think he's lying. I
Yay,
don't.
Margaret.
Yay.
She says, I got moved to the hiring team. I should get a call for an in-person interview.
Yay. I don't know. I
Nice.
was thinking yesterday, oh, yay, Kel.
Kel, crossing
Yay.
fingers and saying prayers, ma'am.
Yes,
Yay.
ma'am. Morgan,
That's
I was
awesome.
thinking yesterday that if you save enough money on dry cleaning, that you could just stay home.
Hmm.
Just saying.
There you go. I personally think that Margaret should stay home, make, Margaret greeting cards,
I would buy
and
all
hang
the
out at the
cards.
crime cafe every day.
I would buy all the cards. All of them. Like, you could do, like, a personalized poem card thing.
Mhm.
Write this down. So, like, I could say to you, "Hey, I need a birthday card for M, and here's some things about her." And then you
Mhm.
could write a birthday card with the things about her in a poem form. I think it would be fantastic. I would buy that.
Do you know what would be even better is if Margaret had, what are those things called? What's that service called where you can, like, pay a celebrity to do, like, a video, like, 30-second video, like, "Hey, I heard it's your birthday."
Yeah. But Margaret could do it and give a, it's, I don't remember what it's called.
Personalized. Yeah, I forget what that's called. Um,
So I'm gonna put this on the screen real quick. That is the link to the Miss King. That's the link to the Adobe thing. You can click it in the chat. Scroll up. You can click it in the chat, so you can read it if you'd like to read it. I hope that's okay. I really should ask permission before I do things.
no, you're fine, honey. Thank you for doing that.
Um, yeah.
Um,
So all these hope. So here's what's happening. I want to clarify. This stuff has been going on for years. Okay, for years, all this stuff, jury tampering, the lying, deceiving, the prosecution's defense, all of them have all been doing this for years.
yeah.
However, now you have social media. What cup is that? I want that cup. Is that from Walmart?
This,
Yes.
I got it on Amazon.
I need the linky link.
It's your big one.
I need the link, please, and thank you.
I'll send it to you.
Yeah. So they're reviewing. They're reviewing, or everybody's paying attention, and they're texting these are messaging these creators, right? And they're like, "Hey, did you see their favorite ones, whoever their favorite creator is?" And they're like, "Hey, Jenny, did you see blah 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 blah?" And Jenny goes, "Ooh," and then here we are reading things on the internet. Which one do you want to do next? The motion for the acquittal or the motion to DQ?
Okay, Jenny cool. Jenny said, "I looked for the exhibits and they aren't fully processed on the Manatee County Clerk's website,
Yeah.
so aren't available yet."
It may be because they are 20 years old, and back then they didn't put everything on the interwebs, that they haven't been scanned in.
No, I'm keeping big eyes there, Margaret.
Yeah, we're talking about Ashley.
Mm.
Talking about Ashley. And again,
Specifically put that up there for you, ma'am.
go back and listen to the beginning. You'll hear it.
Yeah, I did say, yeah.
Also, boss baby, spit my drink out, choked, all the things.
Kel, honestly, Kel said that should have said submitted a resume instead of interview, but I knew what you meant. But I am sending out all the prayers that you get the perfect job for you. And if this is it,
You got this.
then you got it.
Oh, the exhibits. Okay, thank you.
Margaret says, Kel, you're going to start getting your calls. You just watch.
Facts. Hey, Margaret. You got your Tommy Tippy? You should not give me this much power, ma'am. It's bad. Because I'm just out of control.
I think that you should have that much power and wear a pink tutu at the same time. Like she keeps saying I'm gonna give her pink tutu, and that allegedly, allegationously means that she's fired.
My
But
pink slip.
like I would wear, the pink
wear a
slip.
pink
That's
tutu.
why. That's why.
Pink slip.
Like
get it? Get it? Get it?
I get it.
I think that was Morgana. I said you're gonna send me my pink slip, and then she put up a tutu, or I don't know, somebody put up a tutu and then it became a tutu. Anyways, I'll get a tutu.
Yeah.
Jenny
Kel,
saw
you're
me
welcome.
today. Jenny
You're
saw
welcome.
me today.
Do what?
I said Jenny saw me today.
I did.
In my cute
beautiful.
PJs.
QB's beautiful.
Whatever.
She just won't share her beautifulness with us, but that's okay.
I need to know. I am pointing at this like you can see me. I need to know where you got the room divider from.
That
I've been looking
Amazon. Everything comes from Amazon.
Yeah, see, everything the same. Oh my God, you're putting your finger on my TV now. Stop! It's big on the TV. Yeah, I need that because if I had that behind my chair, so y'all couldn't see my kitchen. It's not bad. It's just I don't have any room. We have like 2 cabinets in the whole kitchen. It's ridiculous.
Yeah, I got that room divider. A year and a half ago, maybe 2 years ago.
I'll have to look. I've been looking at them on a China site. But yeah, I get everything from Amazon. I love Amazon.
Jenny, same. It's Amazon or nothing. Amazon or if I can't pick it up or get it delivered like soon, I always go to Amazon first unless it's cheaper at Walmart.
I don't even go pick up a Walmart delivery order or pickup order. I have it brought here. And if it can't get
do that, I would do that if they delivered out here, but they don't deliver groceries out here to me.
I have even broken down on several occasions, which I swore I would never do, and paid the $3 get it in 2 hours thing.
That's pretty cool though.
It is because
I wouldn't know how to act if somebody delivered groceries to my house.
Girl, it's so fantastic. Look,
I bet.
listen. So the 3-hour thing is $3, right? Now there's sometimes, and I'm like, I am not paying $3 plus a tip because I'm always going to tip.
Mm-hmm.
But then, like every once in a while, okay, when the hurricane came, you couldn't get a spot for delivery for like 2 days. But then you could put in your little $3 and you could get it in 3 hours. And I was like, okay.
Mm-hmm.
And so then what they do is they shop your order. If there's something missing, they text you and they're like, hey, you want a substitution, whatever. And then when they're on their way, they text you. They're like, we're on our way. And then when they're almost here, they go, hey, we're almost here. And then when they drop it off, they go, hey, it's on your front porch and here's a picture.
Wow.
I love it so much. So much.
That's pretty cool. Okay, QB, I'm going to let you go to the next one, whichever one you want to do next. Because I think there's 3 motions altogether?
Yeah, so there's a motion to interview jurors, which we did. There's a motion for acquittal, and there's a motion to DQ the judge. Let's do the DQ the judge, and then we'll end it with the acquittal because that should have all of it in there.
Okay. I have to go wee-wee, so you continue, but I've got to go wee-wee. So I'll be right back.
We'll set it up. Okay, I'll be here. All right, let's look and make sure that nothing is showing. Yeah, Instacart is good. I used to do Instacart during the pandemic. I totally did Instacart. Made bank, major bank. Share screen. Share screen. What did we say we're doing? Motion to DQ. Okay. Yeah, I love Instacart. But oh yeah, you get a link. So when you do the 3-hour thing, you get even more access. Like you can text with your shopper, kind of like on Instacart. It's fantastic. But yeah, so Instacart, like I said, I did because when everything shut down, I mean, like I was in construction at the time and it was awful. Everything like closed and you couldn't get materials and all the public offices were closed, so you couldn't get permits and it was a whole hot mess. So yeah, I started doing Instacart and it was cool. I actually really enjoyed doing it. But anyways, okay, I'm gonna get to this. All right, so this is the they spelled her name wrong. Bro, he was doing this so quick that he spelled her name wrong. Ashley Benefield's motion to disqualify the Honorable Stephen M. White, supporting affidavits and incorporated memorandum of law. Now, I'm not gonna lie to you, I skimmed over this last night because the meds were kicking in, and I was like, I can't read it. I'm kind of like uh kind of offended. Just because I thought that, and y'all let me know if you feel the same, but I thought Judge White was very fair. I didn't see any bias, even though the whole entire trial, dude was trying to say he was biased. I didn't see it, but maybe it's just me. Um, Tiny Table Guy 2.0, if you type this, you spelled her name wrong. We need to know his name. The other guy, Tiny Cable Guy, the original, I think his name is Craig. I think it's Craig. Anyways, Ashley Benefield, by and through underside counsel and pursuant to section and the rule of the things, hereby submits her sworn motion for disqualification of the presiding judge. Ms. Benefield, I just don't believe it. Ms. Benefield fears and believes in good faith, based upon objective facts, she will not and cannot receive a fair hearing and or sentencing on account of the personal bias and prejudice of the presiding judge against her in the favor of the state of Florida. That was a long sentence. Basis. The court's conduct in open court immediately prior to commencement of trial on July 22nd, 2024, and at the July 30th, 2024 verdict improperly prejudiced the defendant. Specifically, the court's declination to voluntarily step aside, as well as the court's arbitrary and capricious refusal to so much as even acknowledge Ms. Benefield's request for post-trial bail, created such apprehension for Ms. Benefield that she reasonably fears she will not receive a fair hearing and or sentencing because of the court's personal bias and prejudice against her. Y'all are being quiet. Did y'all see bias from this judge? Seriously. Did y'all see? Here, ma'am, you killed somebody. You're not getting post-trial bail. It's not happening. And I understand your apprehension if you were allegedly a victim, but that judge was like to me, was the nicest, fairest judge ever. I don't know. Did y'all see it? I didn't see it. Are y'all still here? Can you hear me? I don't know. Can you hear me?
I hear you.
Okay, I'm just making sure because nobody's talking and I'm asking questions.
Oh.
Anyways, okay. Oh, there we go. No, I really like the judge. Yeah, Morgan, I don't understand. So did you see what I just read? He said that specifically hear this, Jenny. Specifically, the court's declination to voluntarily step aside, which there was no basis for him to do, as well as the court's arbitrary and capricious refusal to so much as even acknowledge Ms. Benefield's request for post-trial bail, created such apprehension for Ms. Benefield that she reasonably fears she will not receive a fair hearing and or sentencing because of the court's personal bias and prejudice against her. Bro.
I'm sorry. I'm one of those that has to see it like I have to read it. My brain has to see the words.
No, I feel that.
Yeah.
So, okay. You killed somebody, you don't get bond. And if you get bond, it's going to be like $5 quadrillion.
Mm.
Like no previous disqualification motion has been filed in this case, and a transcript of the post-verdict bond request is attached. Exhibit 1. The actions taken by the court, i.e., its complete refusal to even acknowledge the defendant's motion, yet alone entertain, evaluate, and rule on it, plainly appeared to the defendant that the court never intended to consider it, and remand was the only option. Given the court's consistent display of prejudice against Ms. Benefield, he gonna piss this judge off, Ms. Benefield, and in favor of the state throughout the trial. Were we watching the same trial? Were we? And he says no previous disqualification motion has been filed. He didn't put it in writing, but he made like 2 or 3, I think, motions to the court to DQ, to remand.
Jenny says, I didn't see the judge as biased, but he thinks defense is incompetent and he allowed the prosecutor a lot of DV bashing.
I agree, but the way, okay, so here's the thing though, Jenny. The prosecutor made me sick, like legit, to my stomach, made me sick. However, the questioning that she did was not outside the law. So there wasn't a whole lot that the judge could do to stop it if the defense didn't object to it. And I didn't understand it, but the defense like let that whole thing, that whole reenactment go on and never objected. Like, I don't know if he thought it was helpful to his case. See, Jenny just said, but defense should have objected to more of her antics. Yeah, it was sickening. It was absolutely sickening. It was terrible. And prosecution, because we know you watch, don't do that. Cut it out.
Yeah, I didn't care for the blonde prosecutor, but the darker haired one, I liked her better.
I liked her better, but she was still kind of disparaging.
Harsh.
The problem that I have is that, again, and I don't know, were we talking about this before or on the live? I can't remember. But my problem is that it will keep people from reporting and filing charges. Now, Florida, and there's numerous states, I don't know which ones. I do know Florida for a fact is that the victim no longer is responsible for bringing the charges. It's the state that brings the charges. So if the police come out to a call, she did lie in closing. If the police come out to a DV call and they find a probable cause, when they make the arrest, the state is then the one that brings the charges. It's no longer the victim that does, because the victims many times will pull the charges back.
Yeah.
And I know a lot of states are like that now, but what?
Oh my God. Hold on.
What?
Hold on. You go ahead. Share the screen. I gotta go look at something real quick.
I thought I shared the screen. Oh, I didn't. Okay. My bad. What happened? Oh, I've been reading this thing and y'all couldn't see it. I'm sorry. My bad. I'm sorry. Defense didn't object. I think Ashley could have some ineffective assistance of counsel claims because her lawyer was super sick at the end and not so effective. I agree. Right? She like was like, oh, hey, Dobby, hi, friend. My friend. I love you, Dobby. You talking about me ain't sorry or Jenny ain't sorry? Jenny ain't sorry. She did a big old gasp and then left. All right. Am I sharing my screen? I'm still not sharing my screen. There. Now am I sharing
Oh
my
my God. Oh my God. Oh my
What?
God. Oh my God. Hold on. I have to share my screen real quick because we have some breaking news in the Matthew Perry case. Our friend Chandler Bing. Hold on. I have to share this. Hold on. Share screen.
Where'd you see this? It didn't come up on my thing.
Look at this. All right, watch. At least one person has been arrested in connection with the death of Matthew Perry, NBC News and AB7 report, citing law enforcement sources. The person arrested was not identified, and it is unclear what charges they could face. People has reached out to the Los Angeles Police Department for more information, but did not immediately hear back. Hold on a second. There was another article that I saw. Oh, where did it go? Where did it go? Where did it go? Where did it go? It's a doctor.
Ooh. He was giving out prescriptions.
Police have reportedly arrested multiple people.
What?
Oh my God. Yes. Yes, yes, yes.
Yay.
I'm sorry. You guys can think what you want to think. I know he's Matthew Perry is a grown adult man, but this is something that I just said about my nephew
He
who
was
passed away
vulnerable.
from a
He was
drug
vulnerable.
overdose the other day. I've got a second nephew who just passed away from an overdose just days ago. His funeral was last week. 35-year-old man. My nephew, right? These people, Matthew Perry, grown ASS man, can make his own choices to do what he wants to do with illegal or prescription or whatever you want to call it. But unless or until the people that they get that from start being held accountable,
Yep.
these dealers or whatever you want to call them,
Yep.
unless or until those people become accountable, it's going to just continue and continue and continue and continue. And QB mentioned a story yesterday about a little baby who got hands on things. Ween Baby was just
Allegedly.
in this chat the other day talking about
Yep.
someone she knows
Her
whose
cousin.
baby got a hold of some things. And
It's
this is
fentanyl. Say
good
it, Jenny.
news.
It's fentanyl.
Well,
Did
with
you change
Matthew
your settings?
Perry, I don't think it was fentanyl. I think
No, it
it
wasn't.
was ketamine, but still.
It's still. Did you change your settings? Because I'm echoing.
No.
Why am I echoing?
Probably because I'm over here screaming my full head off.
No,
But
it's fine.
I'm excited.
I am too, because here's the thing, like you said, he is a grown man, okay, and he can make his own choices. However, he was vulnerable, okay? He was an
Mhm,
addict
mhm.
and he needed help. He didn't need someone. Now, if he was going and having the ketamine shots or whatever, I don't have a problem with that, but somebody supplied him with too much. And I think he had propofol too, didn't he? Wasn't there propofol found in his system? Why was I thinking he had propofol?
I'm thinking that ketamine and propofol are basically very similar, aren't they? Aren't they the same
They are, but
thing?
they're not the same.
Okay.
All right, Margaret, be careful.
Jenny Trioli, you're right. I get that. Um, I know what you mean. Fr Doctors are guilty of it. With the fentanyl problem, though, you know,
Well,
that's
here's
a whole
here
other beast.
you might want to put up my my trigger thing,
We
whatever.
got way off topic here,
I'm
but
okay. It's important, Jenny. It's important. Here's what I'll tell you about fentanyl. My personal opinion is fentanyl starts with the doctors. The fentanyl addiction starts with the doctors. They prescribe it. They do the patches. They do all the things. They keep upping it until they can't go any higher, and then you become tolerant to it. And uh, then you can't get it any higher. You also can't come off of it. It's almost impossible to come off of it. There's nothing there's nothing equivalent like the Suboxone that you're saying, Jenny. I think that was for the opiates, but it doesn't work for fentanyl.
right.
And there is no type of that I'm aware of, and I have very personal um knowledge of how this works with fentanyl. And um you basically have to go to a clinic and go cold turkey, and they treat you for um the side effects of withdrawal, but there's nothing to help you with the withdrawal, and it's very terrible. The other problem I know that we have here is that people are lacing marijuana with fentanyl
Mhm.
to get people addicted.
Mhm.
And then once they get them addicted, then they become their dealer for either the laced or the fentanyl.
Mhm.
And it's very bad here. And both of those cases that we were talking about, the fentanyl with the kids, are in my state.
Yeah.
So, um, anyways, I'm
It
glad. I'm happy. I'm happy. I'm happy and like you said, he's a grown adult and he can make a decision. But when you have an addict who's vulnerable and you're handing them the stuff, putting it in their face, what do you think they're going to do?
right. Right.
So you're culpable. It's just like if you have an alcoholic child who's drunk and you give them your car.
Yeah, right.
Do you know what I'm saying? Like I feel like I don't know. I feel like it's the same.
So I'm looking for newer articles. The thing that bothers me though is the people who think that they're getting one thing and then it's got all the fentanyl in it and they have no clue, and then they're screwed. You know what I
That's
mean?
that's the thing. That's what bothers me because you know, we can not get into the discussion about marijuana and if you know, good, bad, or indifferent, or devil's lettuce, or whatever this case may be. But if you think that you're getting marijuana and it's laced with fentanyl,
Mhm.
there's so many issues with that. One, overdose. Because if you're smoking, you're getting all those doses of fentanyl.
Right,
Two
right.
is addiction, and you become addicted. And then you think you're addicted to the marijuana, which may or may not be the case, but you're also addicted to fentanyl. And then if you don't smoke, then you have withdrawals. It's terrible. It's terrible. Fentanyl is a huge problem in this country. Huge.
This is from another news source. It says uh hold on,
Agreed,
where did
Jenny.
it go?
Absolutely agreed.
Says
100%.
TMZ reports at least one doctor and several dealers who helped deliver ketamine to Perry have been arrested.
So it's probably the girl
They said that the Brooke Mueller was not arrested.
so she turned. I bet she
Well,
turned and gave up the other people.
I mean, we don't know yet. It could have just been that, there was information that, I don't know
Well,
that
she was
she
involved. So if she didn't
turned.
get charged, she turned.
Well, they said that they their devices to see. Now that I'm being naive, I know that, but what I'm wanting to say is that it may just be that she had information and they found the information. Maybe she didn't willingly give the information. You know what I'm
Right.
saying?
Right, and I
But I
agree
don't
with what
know.
you're saying, but it was already shown that she was involved, right?
It was not shown that she was involved in a
Just that she had
criminal
information?
way.
Okay.
Yeah.
Okay.
They said that she was involved. They were investigating her, but they never, like, I don't think that they ever come out and said that it was like a criminal investigation.
Like she was connected?
For sure. People were looking at it that way, but they never, like, confirmed.
It may have been she was just like a drug buddy.
Right. That's kind of
She was
what.
using, right?
Yeah.
Okay.
But they were both in rehab together.
Right.
And
Okay.
so, yeah. This is from TMZ. It says arrest made in connection with ketamine, drug doctors and drug dealers in custody. Big break in the Matthew Perry death investigation. There have been multiple arrests made, including at least one doctor, TMZ has learned. Law enforcement sources tell us multiple law enforcement agencies have executed search warrants and seized computers, phones, and other electronic equipment to determine who supplied Perry with the ketamine that caused him to lose consciousness last October and drown in his hot tub. Perry had been getting ketamine infusion therapy for anxiety and depression, but the last therapy was a week and a half before his death, so the ketamine in his system was not doctor prescribed because the infusion had already left his system.
Yeah, I remember reading that after the autopsy.
Right. Um.
Plus, I think the level was higher than what they were giving him.
Mhm.
I could be wrong. I'm not gonna lie. I don't know a huge amount about it. But if I remember correctly, the amount that was in his system was also higher than what the dose would have been anyways.
TMZ broke the story. Perry had the same level of ketamine in his system that is used for general anesthesia in surgery.
Yeah.
Law enforcement sources tell us the ketamine Perry ingested was not legally prescribed, and multiple agencies, including the DEA, U.S. Postal Service, and the Los Angeles Police Department, have conducted a criminal investigation for months. We're told at least one doctor has been arrested, along with several dealers who helped arrange and deliver ketamine to Perry. Other sources say the search warrant revealed text messages discussing Perry and the ketamine he wanted and what they were doing to get it to him. The texts also discuss the price the friend's actor would pay for the drug. Sources tell TMZ authorities got a search warrant for Brooke Mueller, Charlie Sheen's ex, who had been in treatment with Perry, but as far as we know, she is not connected to the arrests. In their investigation, authorities found other celebs who were involved in the Hollywood drug scene.
There's going to be some celebrities in this arrest. I'm telling you.
These arrests make it clear authorities are making it a priority to go after doctors and dealers who illegally push drugs. Notably, Ryan Rivas, I don't know who that is, got an 11-year sentence as the middleman who delivered drugs laced with fentanyl to Mac Miller, resulting in the rapper's death. Story is developing, so I'm going to keep up to date with that because this one's got my heart. I love Matthew Perry.
Hey, Michelle, welcome back.
Welcome back. Welcome back, Michelle.
Yeah, and Jenny, to what you said, one, you can have an opinion whether you smoked or not smoked. Two, I agree 150% that every state it should be legal and regulated because then you don't have to be concerned about people lacing stuff. And I say that as a mother of a child who uses it medicinally. And it scares me to death. It scares me to death. Fortunately, he has somebody that, whatever, but it scares me that he could get a hold of something bad.
It's a very scary thing, and I mean, they've even said, you have to watch like the gas pumps and stuff around here because they say that Sometimes
Yeah,
they'll
you put
have
fentanyl on it.
put fentanyl on the gas pump handles, and
Yep.
you never know. I mean, it freaks me out. I'm always like, "Ooh," you
It's
know?
it's not good. It's a problem. It's a huge problem. Well, we're glad you're back, Michelle and NC.
Yeah. I'm glad you're back, Michelle. It's good to see you back.
Yeah.
I like
Um,
your profile picture too. It's super cute.
oh wait, I gotta go look. Hold on. Let me go look. I can't see it. Oh yeah, I love that. Careful of them glasses. They arrest. They kind of girl. What was I gotta stop watching this when I'm sleeping. 48 hours. They arrested and charged a girl and based off of her glasses. She had the mirror glasses like that, and she was taking selfies, and she was in front of the building where she killed the dude, and it was reflected in her glasses.
Oops.
So it can be absorbed through the skin, Miss King.
Mhm.
Also, like if you get it on your hands and then like rub your eyes or your mouth or somewhere that's open per se, um, yeah, it's bad. It absorbs through the system. Almost all U.S. currency, yes, yep. U.S. currency, y'all don't be touching dollar bills and then touching your face or your mouth or your nose holes or your eye holes.
No, there's way more than just Coke
It's gross. It's
on
gross.
money.
Y'all don't do it.
There's
Y'all don't.
bodily fluids
Ew, it's so gross. It's so much fungulitis. Like, no, no.
and
The
poo.
and the bottom of your shoes also. Don't touch
Yeah,
those.
and don't put your purse on the floor of the
Floor.
bathroom stall in a public bathroom.
Ew.
Never,
On the floor
never.
anywhere.
Brr.
Anywheres.
Yuck.
We did a we stripper money, right?
Dollar, dollar, make you holla.
That bra money, look, there's places in Florida like that, and
Mm.
y'all, I'm not in Florida anymore, but I was in Florida. I was an original. I was born and raised, so yeah. Um, but there's stores in Florida that says we don't take boob money or we don't take bra money
Mm.
because it's sweaty and nasty. It's nasty, y'all. Nasty.
Yeah, we don't take the boob sweat money. No.
No, we don't take the boob money. We don't take the bra money. Don't be reaching down in there getting change. Um, purse on the floor, money out the door. Uh, no. We did a college in one of my biology classes. Was it biology? I think it was biology. Anyways, we did a test and we swabbed. Like we got to pick 4 areas that we wanted to swab to see where we would get the most fungulitis from. Y'all, we did. I can't remember the 4th one. Did the bottom of the shoes, underneath the fingernails. Oh, we did a toilet seat in a public restroom and the handle from the public restroom. I want y'all to tell me which had the nastiest fungulitis on it.
What were the options again?
Okay, the bottom of your shoes, underneath your fingernails, the toilet seat at a public restroom, and the door handle leaving the public restroom.
I would go with your fingernails.
Okay, Sherry says shoes. I'm gonna wait a few seconds. Door handle. Okay. Do I sound like Darth Vapor? Can y'all hear that?
No.
Because I don't have any. I don't have any noise canceling on. Okay. Who else? Fingernails. Handy fingernails. Okay. Wait a minute. Wait a minute. See if anybody else has games. So gross. It's so gross, y'all.
Wait a minute, Mr.
Postman.
Postman.
Okay. Kel says door handle. None of y'all said the toilet seat, which surprises me. And it was not the toilet seat. It was
Sorry.
your freaking fingernails. And shoes were a very close second. That's why when people say, "I don't wear shoes in the house," I understand all of that.
Mhm.
There is some major fungalitis going on the bottom of your shoes. But under
Mhm.
your fingernail, y'all ever, like, be, like, biting your nails or something? Don't be doing that. Don't stick your fingers in your mouth. That's nasty.
Right.
Gross.
It's funny because that's what, the doctor was telling Jolie. Was it Monday? Yeah. She was telling Jolie on Monday, she's like, "Make sure to wash your hands really good at school all the time and use the hand sanitizer."
Mhm.
But,
Yeah,
they've said this here, and you're gonna think that okay, so I'm just gonna be honest and tell you this. I learned a long time ago, there was some kind of a test or study done, and they said that if you wash your hands in a public bathroom and then leave the bathroom, you have more germs on your hands
Yep.
then than you do if you don't wash your hands and leave the
Yep.
bathroom.
Check this out. Remember back.
Because but see, now that was back before they started with the whole, like, automatic water washy things now,
Right, right.
but this was back in the day when you had to turn the handle,
Kelsey
but
Kel said, "My nail biting builds my immunity." You are not wrong.
I'm a nail biter too. I mean,
You are not wrong. Yeah, so,
but I'm sick, so
do do you remember back in the day? Okay, where's my Gen X people? When you would go in the bathroom and they had one solid cloth that was just hanging from the thing that was in the machine, and you would pull it down and it would give you a quote unquote clean spot, and you would dry your
yeah,
hands, and
yeah.
everybody and their brother had dried their nail salons. Look, you got to find you a good, y'all got to find good nail salons that clean their stuff.
Yep.
That clean your stuff. That's nasty.
It's pretty
Nasty.
gross, pretty gross.
I have a sanitizer thing, um, for my, not a good endorsement for now.
I
Zombie's
know,
like,
right, Morgana?
"Eh."
Hey, Elizabeth, I didn't see you in here.
Yeah, she
Hi.
been here. She came in earlier. Um, she just being quiet and she's like, "Eh." Yeah. I have a little sanitizer thing that I use for my own tools for my nails that I use on myself. I also do, I do M, so I clean her stuff too. She keeps picking up, okay, look, I ain't trying to call nobody out, but she keeps picking up a toe fungalitis from the people she goes gets her toes done. I said, "You gonna stop." And I don't like feet, but I'm fixing to do your toes because I'm gonna need you to stop getting the funk.
She needs to take her own little tools.
I'm not, no, she's well, and then I told her that I was like, "If you want, we'll make you a little," because I can get steri packs. And so what you do is you sterilize the tools and you put them in the steri pack and you seal it, and then she could carry it to where she goes. But 3 times in a year and a half, she has gotten fungulitis in her toe. I'm like, "Ma'am, stop it." Ooh, I would
Kel,
say,
I do the same thing. I use the paper towel that I dry my hands with to open the door, pull the door handle, and then usually what I'll do is I'll use my foot or my elbow to hold the door open while I toss the paper towel in the trash and then walk out.
well, that's why most places have put a trash can by the door now because people were
Mhm.
just throwing their paper towels on the floor. They'd open the door and there was nowhere to throw it, so they would just throw it on the floor. Um, but, yeah, Morgana, I would say fingernails. I would say
Yeah,
fingernails,
because
'cause especially with
toenails aren't scratching things and picking things up, and I mean, I don't know, but
I'm also not putting my toenails in my mouth, ma'am.
no.
I don't put my fingernails in my mouth either. Every once in a while, I'll be wanting to, like, get something out from underneath it or something like that, or I'll have something stuck in my tooth, and I'm like, "Nope, where's the flossy thing? Y'all can get them at the $1.25 tree. Go get you a bag."
Here you go.
Kel
I
Reddick, you do
always
not
have
have
one
to.
handy.
Do you bite your toenail? There are people that bite their toenails. Do you really bite your toenails, Gail? Seriously, for reals? I
I
know. I always.
used to. I used to bite my toenails whenever I was little. I
You
did.
are nasty. Stop it.
I always did. I can't anymore. I can't even hardly get my feet up on my daggone knees to put my shoes on anymore, but
Oh Lord, my computer is all frozen.
uh-oh.
Well, you can still hear me, so what's up with that? Can't click on anything though.
So now left and right, it's popping out about Matthew Perry on Twitter. At least one arrest made, at least one arrest made, at least one arrest made. But I'm ready for some names to drop.
Yeah, I'm gonna need some schmintfo.
Mm-hmm. How much more do we have to go on reading these documents?
Well, I'm trying to get to them, and I may have to come out and or go out and come back because I can't click on anything. Like I don't.
Uh-oh.
Reload. So okay, if I go away, I'll be right back.
Okay, no worries. And she went away. There was no ifs, ands, or buts about it. She's like, okay, bye. Bye. Spin says, why are we talking about toenails? Don't make me throw up, y'all. We were talking about how fingernails are the grossest. They have the most like fungal junks, yucky germies under our fingernails. My throat is raw. I've got tea in there. Well, I'm going to have to heat it up probably now, but I got some. When I went to go to the bathroom a while ago, I made me a cup of peppermint tea and then I forgot about it. So now I got to go get it and put a little bit of honey in it and hopefully that'll make my throat feel a little better.
Let me
Do you
in.
need help?
Oh,
there
hi.
you are. I added you, so.
Yeah, I know, because I'm stuck. Like I'm stuck. I'm on my phone now. Can you hear me?
Yeah.
Okay. Fungal jungles. Ew. And Morgana, keep them feet off the screen. What is wrong with y'all?
Fungal jungles. Michelle says, BRB, I'm working too. All right. No worries.
So let me go over to nope. Because I'm trying to shut down my computer right now. I don't know what happened, but my whole computer was like, nope. Failed to quit. Google Chrome is doing the most right now. Force quit. Yes, I don't like Chrome. I hate Chrome. But whatchamacallit, StreamYard don't work on other stuff. Can y'all hear my cat doing the most on that cat scratcher?
No, I can't hear nothing.
She's doing the most. Oh my! I mean, she was going to town. All right. Turn it sideways so I can see it. Ow. Oh wait, I'm back. I'm back. I'm sorry, y'all. I don't know what happened. Like it just literally was like, nope. Okay, open. Let me open. Okay, I'm back. I can read it from my phone.
Okay.
But I can't share it. Unless you want to wait for a second for my computer to come back up. But I don't know how many pages this. Oh Lord, this one's 7 pages. I mean, I can read it fairly quickly. The thing with Robert Tellis, I'm going to tell you, we're going to be able to speed racer through that.
Good.
There was a couple witnesses that the defense didn't even cross, and they haven't even started for the day. What time is it?
Well, they don't start. Well, are they going to continue to start at 10:30 every morning for them?
I had heard that they were going to start at 8:30, but I don't know when that is. I think she had like court things to do in the morning for a couple days. I don't know. I might be making that up. Let me go see. Did you hear that? That was like very loud.
Mm-mm.
I know. Yeah, see, Law and Crime isn't starting the coverage until 2 p.m.
Mm.
Chrome didn't shut down correctly. Restore. Oh, look, they all came back. What the what? That was very kind of them to reopen everything. Yeah, I don't see. Look, my camera trying to show me. Nope. Okay, it's gonna. Hold on. Yikes! Don't add me.
Okay.
Let me get out of here. All right, are we good?
Say something.
Can you hear me?
Yeah.
Okay, cool. Hey, look at me doing the things.
Yay!
Sorry, y'all. Jenny's a professional. I am not.
I'm hardly a professional, ma'am. I'm
Jenny,
just.
Jenny, put those feet away. Ew. Okay. Motion to disqualify. Let me go back over here. Jenny is actually huge professional. I am not.
Mm-mm.
Tutu. I'm going to get a tutu.
No. No.
My computer is not a fan of all of this. I don't think.
Mm.
Here we go. Acquittal, motion DQ. Yay! Oh, I didn't check it for stand by.
Oh no! Did you do something?
No, I almost did. Let me. It's coming up. Let me get the motion up and double check to make sure it didn't dox me. Okay.
Okay.
No. Okay. Here it is. All right. I got it. It isn't. I'm not. I'm sorry. My bad. Okay. Share screen. Motion DQ. Sure. Share. Okay. Can you see it? Is
Yeah.
it moving? Is it
Yep.
moving? Yay. My computer. Oh, see,
Oh.
I told you, punk. So
Mm.
it's fine. It's fine. I told you it was going to come up. It's fine. I told it no, and then it did it. So it's fine. It's fine, Jenny. I have a name. Okay, memorandum is where we were. Why is my computer being stupid? Let me shut some of this down here.
Well, you got 52 tabs open like I do all the time.
I do apparently. And my computer is like, no, ma'am. Or it could be my intrawebs. I apologize, y'all. Give me a second. It's not moving. There we go. It's really slow. Okay, memorandum is where we were. It is the established law of the state that every litigant is entitled to nothing less than the cold neutrality of an impartial judge. State v. Steele. In this instance, Ms. Benefield received anything but that. You a whole lot, sir. Canon 3 of the Florida Code of Judicial Conduct declares a judge shall perform the duties of judicial. There's a whole lot of footnotes there, y'all. Office impartially and diligently. Under subsection E, entitled Disqualification, it states that 1. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the instances where A. The judge has a personal bias or prejudice concerning a party. F. The judge, while a judge has made a public statement that commits or appears to commit the judge with respect to II. an issue in the proceeding, or the controversy in the proceeding. I feel like you a whole lot, sir. Quoting from its earlier decision in Barnes. Do you want me to read the decision?
No, I mean, no, not if you don't want to.
Well, let's see what it says, because I don't see where he's coming from at all for the bias. I didn't see it. I don't know. Maybe y'all saw it. I didn't see it. In making that determination, the court has often pointed out that judges should be held to a higher ethical standard than lawyers by virtue of their position in the judiciary and the impact of their conduct on public confidence in an impartial justice system. Holy crap, that's a lot of words in a sentence.
I hate when they do that.
It's like a lot, yo. Okay. Accordingly, no other principle is more essential to the fair administration of justice than the impartiality of the presiding judge. See that case. Holding that judge failed to promote public confidence in the integrity and partiality of judiciary when he injected himself and his office into a case by advocating for a defendant. Sir, oh my gosh. Okay. Immediately prior to trial getting underway, i.e., before voir dire and jury selection began, undersigned counsel appealed to the court's sense of integrity and oath of office, wherein the court agreed to uphold the fair trial provisions of the Constitution of the United States, as well as the Constitution of the state of Florida, and beseeched the court. I like that word, beseeched the court to disqualify itself and step aside. Specifically, undersigned counsel raised the issue of the court's conclusion embodied in its order denying Ms. Benefield's stand your ground motion. She didn't have that. And inquired how the court could possibly sit and decide the issues objectively when it had already publicly concluded Ms. Benefield was guilty as charged. The request was ignored. Okay. So, he's not wrong that the request was ignored. Because y'all remember, like, he did the whole thing, and then the judge was like, so, anybody got anything else? Anybody?
Right.
But just because he denied the stand your ground motion, which I don't feel like that they proved that she had I don't know. I didn't see it. I didn't see the bias. But he ain't wrong that he was ignored, because he legit was like, I think you should recuse yourself. And the judge was like, so does anybody else have anything? Is there anything else? Anybody? Bueller? Section 3810, Florida statute and rule, blah, 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 of the Florida Rules of General Practice and Judicial Administration covers such motions as this. See City of Fort Lauderdale v. Palazzo. The rule may be invoked when a, quote, party reasonably fears that he or she will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. Subsection H limits the judge against whom such a motion is filed to determine only the legal sufficiency of the motion, and she shall not pass on the truth of the facts alleged. When a party seeks to disqualify a judge for alleged bias, the facts and reasons for the belief of prejudice must be taken as true, and the judge may only pass on the legal sufficiency of the motion and supporting affidavit. Brown v. St. George Island. He's saying a lot of words that don't mean anything. The standard for legal sufficiency has long been established. The test of sufficiency of the affidavit is whether or not its content shows that the party making it has a well-founded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It is a question of what feeling resides in the affiant's mind and the basis for such feeling. Okay. Hypothetically.
I'm here, ma'am. I'm just blowing my nose.
I'm just kind of talking it out. I'm talking to myself. So if the affiant, which would be Miss Benefield, feels like she would not get a fair trial because she feels like he's biased. Does that trump? That's a hard one. That's a hard one because if he denied her motion to stand your ground and she felt like she had I'm not an attorney, y'all, just if he denied the motion to stand her ground and she felt like that meant that he was biased against her, and in her mind she felt like she could not get a fair trial, does that trump like the truth of the matter? Because that's kind of what that's saying. The test of sufficiency of the affidavit is whether or not its content shows that the party making it has a well-founded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It is a question of what feeling resides in the affiant's mind and the basis for such feeling. That's interesting. That case that they decided. And then the Florida Supreme Court previously explained the analysis required in determining whether such a motion is legally sufficient. A party seeking to disqualify a judge need only show a well-grounded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It is a question of what feeling resides in the affiant's mind and the basis for such feeling. The question of disqualification focuses on those matters from which a litigant may reasonably question a judge's impartiality rather than the judge's perception of his ability to act fairly and impartially. So basically, they're saying that she feels like, for whatever reason, that he's biased and she's afraid that she's not going to get a fair trial. How do you prove that that's the case? How do you prove that?
I don't know how they can. I mean,
I
can't prove what he's got going on in his brain, you know?
And you can't prove what, I mean, she could testify to the fact that she feels like, exactly, Miss King. That's what I'm saying. Like, if a judge has ruled against the defendant and the defendant feels like they're in the right, I mean, like, take Sarah Boone. Okay. You rule against Sarah Boone, she's going to talk about it for 4 years from now that it was unfair and you didn't listen to her and you misconstrued what she was trying to say. And she clearly said it properly, but you just don't know how to hear it. Like, I don't know. That's a Supreme Court ruling though. There must have been something. I mean, he's probably cherry picking out of the decision what he wants. There has to be something in there that the judge showed an actual bias. Because I don't think him ruling against her on the motion, the stand your ground motion, I don't think that shows a prejudice. For me, I mean, I watched that hearing personally. I didn't think that showed a bias, but
I mean, I felt like he was very
so
neutral. Fair. I felt like he was very, very fair.
So fair. Okay.
Maybe this is why he's got, you know, these not issues, but the jury misconduct things in his back pocket so he can be like, okay, well, this didn't work, so here's this.
Yeah, he's been trying to disqualify this judge since the stand your ground hearing.
Right.
And the hearing that they had about Tiny Table Guy 2.0 sitting at the defense table, which is totally ludicrous. It's law. You cannot sit at the defense or the prosecution table unless you are a member of the bar. And I think on the prosecution side, there may be something like if an investigator is sworn in or something like that, they might be able to sit there. But I even think they have to sit to the side. And like
Mhm.
Tiny Table 2 or Tiny Table Original, can y'all hear my cat? This
No.
cat is out of control. She's 14. I need her to act her age.
Ashley Benefield, Kel.
Um, every day this cat runs a loop around my house. Like across the couch, across the table, across the here. And she stops at the scratching thing and she goes, scritchy scratch, scritchy scratch. And then she keeps running. She's 14. Ma'am, act your age. I don't know. There has to be something more in this case. I think he's cherry picking. There has to be something more in that case that showed the judge had bias. Because I just the fact that they ruled against her. I mean, I could see her. Okay, I'm about to be ugly. I could see her narcissistic self being like, "I'm never going to get a fair trial because everyone is against me."
Mm.
That was mean. That was mean, wasn't it? I told y'all I struggle with this case. All right. Given the court stand your ground order, Miss Benefield surely has reasonable ground. See, I don't. Surely has reasonable grounds to believe the court has prejudiced her credibility, and anything she said at trial or will say at sentencing will be ignored. But even more immediately, for purposes of post-trial release, the court's indifference and refusal to even entertain her request leaves her with a reasonable apprehension that creates in the mind of Miss Benefield and her attorney that such efforts will never be evaluated objectively. Dude, you killed somebody.
Right.
You don't get post-conviction bail.
Kel,
Like,
I would say that they're grasping at straws
on this one,
on this one, but not
not
the
on the
jury
other one.
misconduct.
She gonna get a new trial. I'm gonna put $1 on the wall right now. She's getting a new trial.
Were you here, Kel? Did you hear the whole jury misconduct things going on with the Black Swan trial?
Bra.
Two jurors out of
Bra.
6. This was the one that had 6 jurors, and 2 of them are
Tainted. They're tainted. Allegedly, but he's got receipts. A lot of them. It's bad. She gonna get a new trial. This here, I think they're grasping at straws. I think he cherry picked. I mean, I haven't read the decision from the Supreme Court, like this whole decision, but there has to be something in there that there has to be something in there that this judge did to show bias. Not Judge White. I'm talking about the judge in the decision.
Oh, Kel, you have to go back to the beginning and watch through the first motion that we read, that QB read. 2 different jurors in this trial, the Ashley Benefield trial. We just found out last night. One of the jurors had a flip phone in the deliberation room, allegedly, and was
alleganiously
shuffling information out to her brother, who was just so happened to be Law and Crime on Law and Crime Network's Verdict Watch feed, and was typing stuff in the chat about 5-1 vote and so manslaughter and blah 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 blah. And then the second juror's name, or well, their name was out there, but anyway, the second juror issue was juror number 15, who lied in the jury voir dire when they were asked about if they had any
multiple
dealings
times
with DV, because this was a case about DV, right? And the person lied and said no, they didn't. But then come to find out, they have multiple charges against them, and they charged other people with stuff.
And and CPS is involved and all the things. There's the
kids and ex-husbands and wives and things.
Bro, and boyfriends threatening to kill husband, ex-husband. She lied a whole lot. And I agree. She should. I mean, and he said, they signed the affidavit, the thing. I mean, that jury questionnaire is basically an affidavit. Okay,
Right.
you swear under perjury, under penalty of perjury, that you are telling the truth.
Mhm.
So if you sign it, that's as much as you being on the stand saying, "I swear to tell the truth, the whole truth, nothing but the truth, so help me God." Um,
Absolutely, Kel.
and so I think they should be, yeah, I absolutely think they should be held accountable. But there's the link, Kel. That is from the docket
Mhm.
on Twitter, also called Chasing Paper 88, I think. Is it Chasing Paper, the Chasing Paper 88 or something like that?
I think it's
Um,
89 or something, but yeah.
yeah, it's 80 something. But on the Twitter, he's the docket, I think. No, he's at Chasing Paper or something. But if you type in the docket, you can find him. But that link he dropped last night, and that is the link to the motion to interview the jurors. Um, they gonna get a new trial. I'm just saying. I don't even
They're
see
gonna
that.
have, just another side note, sorry, I'm all over Matthew Perry stuff right now.
I know you are.
Um, they're gonna have a press conference today.
What time?
They haven't gotten a time yet, it just says this afternoon, late morning for, because 'cause they're on Pacific
Pick, right?
time, yeah, they're on the West Coast, it's Los Angeles. So, I haven't gotten a time yet, I just keep reading, um, late morning, which would be early afternoon for us, so on the East Coast.
But you get alerts from wherever you're getting that from, right?
Yeah, I mean, I'm what right now I'm looking at Matthew Perry's, like, just hashtag his stuff
Yeah.
and watching the latest things that's coming through, but, hopefully I can find, uh, a time.
Well, yeah. But you should get a notice, right? See, I'm not on all the like the entertainment news and all that stuff. I don't get any alerts on any of that stuff. Like TMZ or I don't know, wherever it came from.
I don't get them from TMZ either. I mean, I'll get stuff every once in a while, but, um yeah, I don't know. I'll keep my eye out on a
Okay.
time. So, I don't know if I'll get a notification, but I might. I don't know.
I just feel like back to this motion to DQ. I feel like hang on a second. Sorry. Trying to get Manchild to help me do something. Um Where's JB? I lost my whole banana nut vape and I'm not happy. I don't know why I keep losing them. That's like the third one I've lost. Um, but with this motion to DQ, I feel like okay, I feel like they say this about defense attorneys all the time. They threw everything at the wall and they're going to see what sticks. I don't understand the motion to DQ when the motion to interview the jurors and to possibly get a new trial is so freaking strong. Like, what is the point? I mean, he's had it out he's wanted this judge off since he denied that stand your ground. And since I think honestly, for him, I think it was more the fact that he didn't let Tiny Table Guy 2.0 sit
Right?
at the defense table
Yeah.
than it was about the stand your ground.
Yeah. Uh,
Can we call
he
him?
was very offended. He's his right-hand man.
He's his lawyer.
Well,
I mean, he's his lawyer. Anyways, I just
mm,
I don't know. I don't understand the motion to DQ when that other motion is so strong.
yeah.
Like it's so strong. I mean, receipts, dates, times, case numbers, names.
I don't know. I think he's just like got one hand in my pocket.
The other one,
How does that song go?
flipping a peace sign or something like that. one hand in my pocket, and well, she changes it every bar. It changes. So it's like I got one hand in my pocket, and the other one is flipping a peace sign or something. And then she got I don't remember. Anyway,
Yeah.
yeah, I don't.
Anyway, they got emotions in all they pockets.
In all their pockets, they do. And I don't. I mean, if I was judge, like, do you ever think that these judges are like, hold on a second, can you grab my one that's charging on the windowsill as well, please? Yeah, thank you. Like, I don't understand. Like, if I was a judge, right? Which I'm not. But if I were, and somebody kept throwing this stuff at me, right? I'd be like, you know what? I'm out. You don't want me on this case? That's fine. Let me remove myself. I mean, I don't want to be where I'm not wanted. I don't stay in rooms that I'm not invited.
Yeah.
I mean, I don't know if it becomes an ego thing or, I mean, I don't think Judge White is really egotistical. Honestly, he may not even know about this yet because God knows that he don't get on the interwebs or the YouTubes because he had heard, oh, it's the other way.
Oh, it looks like the press conference is going to be at 10 a.m. Pacific time, which is 1 p.m. Eastern.
All right, I set an alarm.
All right. I gotta go heat my coffee up. I'll be
okay. I'm gonna keep reading.
I'll BRB. You want anything? Do you want anything? You want any tea? Any snack?
I need another coffee, and I need. Okay. I mean, I'm living vicariously. I cannot believe that you went out at the butt crack of dawn and did not get a I'm sorry for all the noise, y'all.
I don't hear much of anything.
Good. That you did not get an iced coffee.
I didn't today. I can't do it every day. I've already got a problem. So I had to go to town yesterday though to pick up my Walmart pickup order. So, cause where I go to get my iced coffee is in the same town where I go pick up my groceries from Walmart. So yeah, today I didn't have to go all the way into the other place. So I didn't. I just came back home. I'm like, I'm just going to make me a coffee and have some peppermint or not peppermint, some pumpkin spice creamer. So that's what I did. No, it's not to say I won't go get a nice coffee this afternoon. Don't judge me.
Strawberry and a mint.
Sorry. Hi. We're talking about, sorry.
You're good. I'll be right back.
Manchild brought home a Hershey's salted caramel thing. And I'm not usually a salted caramel kind of girl. I'm not going to lie to y'all. I don't mean to chew in the thing. I'm sorry.
Got coffee in it.
This mess is good. Like, it's good. Sorry. Okay. Sorry, I don't mean to smack. Okay. Disqualification is required where the trial court states its belief that a party is guilty prior to trial on the merits. Additionally, Ms. Benefield, now having testified, little doubt remains that the court has concluded her testimony was untruthful. In Carrington, blah, 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 the Court of Appeal noted the test for determining the legal sufficiency of a motion for disqualification is whether the facts alleged would cause a reasonably prudent person to fear that he or she could not get a fair and impartial trial. We have already held that the judge's commentary concerning the credibility of the petitioner before the completion of the petitioner's direct examination or presentation of any witnesses in support of her case is sufficient to create in a reasonably prudent person a well-founded fear that she would not receive a fair hearing before the judge. See, I wonder what that trial was, though. As a general proposition, a statement by a trial judge that he or she feels a party has lied in the case is generally regarded as indicating a bias against the party. Simpson v. States. Statement by a trial judge which suggested that the judge had made a credibility determination sufficient. I just don't remember him. I don't know, y'all. Given the When did he make a public statement to her about her guilt other than when she was convicted? I don't remember that. Do y'all remember that? I don't remember that. Given the court's public statement relative to Ms. Benefield's guilt, its history of impeding the defense at every turn, its handling of the questions leading up to the verdict, and refusal to even respond to counsel's post trial bond request, all created a well founded fear Ms. Benefield would not receive a fair trial and/or sentencing before this court. Ms. Benefield objectively believes the court has now prejudiced her entitlement to post trial release, and her sentencing shall be characterized by an equally biased judicial perspective. Under these circumstances, the court is obliged to grant the disqualification request. Conclusion. It would have been appropriate for the court to have voluntarily stepped aside when counsel requested it, immediately prior to commencement of trial. Now, given what transpired since that request was made, Ms. Benefield involves a formal written request supported by objective facts as well as independent affidavits and undersigned counsel's certificate of good faith. Certificate of good faith. Pursuant to that rule of Florida general practice, I certify the instant motion and statements in support thereof are made in good faith. Neil Taylor, Esquire, i.e., Tiny Table Guy 2.0. Verification under penalty of perjury, blah, blah, blah. Certification of service, blah, blah, blah. Y'all. I don't know, y'all. I just don't see it. I don't see it. I don't see it. Oh, sorry. Sorry. Can you hear me? Hello? Ma'am? Janae? What happened? Can you hear me? I can't hear Jenny. Oh, Jenny went to get her tea. Oh, why are you on Crafty Crafter, ma'am? Okay. But y'all can hear me? I thought I heard Jenny talking for a minute, but I guess I was wrong. Hopefully I'm not going to dox myself again. Can y'all hear me? Okay, cool. Exactly, Kel. That was my point. She's convicted of murder. You're not, I don't mean no harm. You're not special, ma'am. People who are convicted, Margaret, people who are convicted of murder don't get post conviction bail. Like, okay, so Karen Reed, the reason why Karen Reed is still out on bail is because there was no conviction. It was a mistrial. So the same thing that was before the before the mistrial remains. But Ms. Benefield, ma'am, you were convicted of a whole murder, unaliving, sorry, of a person. Convicted. So you don't get pretrial release or post-trial release. It's not how it works. I don't see how that, I don't know. He said that man was prejudiced to her from the beginning, and I don't see it, but whatever, dude. Let me close this. I think they're just trying to disqualify him. Margaret, I have something for you, man. I hit the wrong one. Cut it out. All right. Spins don't start. You were quiet and now you're trying to start stuff. All right, let me share this screen. This is the motion for judgment of acquittal. That is not what I wanted to hit. Hopefully, it's not going to dox me. We'll see. If it does, it'll be okay because I do have a real name. Does appear to be correct. See. You start in trouble, Margaret. You start in trouble. All right. Motion for judgment of acquittal. Ashley C. Benefield by and through undersigned counsel, also Tiny Table Guide 2.0, and pursuant to Florida Rule of Criminal Procedure, hereby moves for a judgment of acquittal. In support of the instant request, Ms. Benefield submits the state has failed to meet its burden of proving beyond a reasonable doubt that Ashley Benefield did not act in self-defense. As such, Ms. Benefield is entitled to a judgment of acquittal as a matter of law. Okay, I don't know if he's gonna go back to the jury thing, but the whole jury found her guilty. So, I don't know how he's doing this motion. I don't understand. Legal standard. Sufficiency of evidence. The legal sufficiency of the evidence to support a conviction is a matter of law for the court, while the weight of legally sufficient evidence is for the jury. Tibbs v. State. A finding that the evidence is legally insufficient is equivalent to a determination that the prosecution has failed to prove the defendant's guilt beyond a reasonable doubt. But they didn't, because the jury convicted her, sir. Self-defense and burden of proof. While the question of whether a homicide was committed in justifiable self-defense is ordinarily a question for the jury, counts have not hesitated to reverse jury conviction. Oh, courts, not counts. Sorry. Courts have not hesitated to reverse jury convictions and discharge the wrongfully convicted when the state fails to carry its burden of proof or when the state's evidence clearly shows that a homicide was committed in self-defense. Macaulay v. State. I'm very confused by this motion. Crucially, the state bears the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. Spins, get back here. As stated in Bolin v. State, while the defendant may have the burden of going forward with evidence of self-defense, the burden of proving guilt beyond a reasonable doubt never shifts from the state, and this standard broadly includes the requirement that the state prove that the defendant did not act in self-defense beyond a reasonable doubt. This principle has been consistently upheld in Florida courts. In Hernandez-Ramos v. State, the state has the burden of proving guilt beyond a reasonable doubt, which includes I just keep saying it over and over, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. Similarly, in Rodriguez v. State, the court reiterated this standard. I'm very confused. Where's Jenny?
I'm right here drinking my hot tea.
I'm confused because didn't the jury find beyond a reasonable doubt that she was guilty?
Yeah.
Okay.
Why?
Because this whole motion is saying that it hasn't been proven beyond a reasonable doubt, and the state didn't meet their burden, so the judge has the right to overturn it if he determines that the judge or that the state didn't prove beyond a reasonable doubt. But the jury came back and said that she was guilty. So, what are we talking about?
I mean, would he rather her just had a bench trial instead of a jury trial, or what?
Clearly, that's what he's looking for now that the jury found her guilty.
Margaret said they found her guilty because of her eyeballs.
You ain't wrong. Okay, I feel like I understand he's throwing everything at the wall to see what sticks, but I feel like he muddies the waters of a very good motion a very valid motion by throwing this crap at the wall. Like,
oh, I'm sorry. Go ahead.
you are so distracted by Matthew Perry.
I am, but I just read something that was super funny.
Go ahead.
Can I read it real quick?
Ma'am, it's your stream. You can do whatever you want.
Listen to this. Somebody named Jesse Ben Israel on Twitter said, "Rest in peace, Matthew Perry. No one mentions his incredible comedic timing and dedication to his craft, just his drug problem. Even drowned on World Swim Day.
Sorry.
Comedy legend. Hashtag Matthew Perry." Talking about comedic timing.
Right.
You know,
They ain't wrong.
even drowned on World Swim Day. I mean, I don't know if that's true or not, but that's that just made it's not funny, but that was like even in his death, he's got the best comedic timing, right?
Could you be any more funny?
Right.
Okay. Uncontradicted evidence. The legal effect of competent evidence, which is not impeached, discredited, or controverted, is a question of law for the court. Holton v. State. In Holton v. State, Brandon v. State. I'm going to need a whole LexisNexis so I can look all this stuff up. In Harris v. State, because I feel like he's cherry picking. In Harris v. State, the court reviewed the testimony of the appellant and his daughter, the only witnesses to the killing, found it to be uncontradicted and unimpeached, and reversed the manslaughter conviction, finding as a matter of law that the homicide was justifiable as being committed in self-defense. There was no judgment of acquittal, as stated in Brown v. State and reiterated in Garmis v. State. As a general rule, when a defendant moves for a directed verdict of acquittal, he admits all facts and evidence adduced in every conclusion favorable to the state, fairly and reasonably inferable therefrom. A motion for directed verdict of acquittal should be granted where it is apparent that no legally sufficient evidence has been submitted on which a jury could legally find a verdict guilty. Brother, they did though.
I know, it's almost like they're writing this as though
it never happened.
They haven't had the trial yet.
Like, bro, I don't understand what you're saying, sir. I don't understand. Okay. While this standard requires the court to view the evidence in the light most favorable to the state, ding, 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 ding. There it is right there, sir. It does not relieve the state of the state's burden to present legally sufficient evidence to support a conviction. Now, here's what I'm going to tell you. I wanted to believe Ashley. I tried to believe Ashley. I did not believe Ashley. Not that she got to self-defense. Okay. Mm-hmm. I'm not saying she wasn't abused. I'm not saying any of that. What I'm saying is that I don't believe that it got to the place where she had to shoot him in self-defense. I can't get there. However, I will say beyond a shadow of a doubt, and I said it before, the prosecution did not prove their case. I don't know how they came to a guilty verdict. Not going to lie. I don't disagree with him. I don't think they proved their case. No way, shape, or form. I don't believe it. But, and I guess that's why, I don't know, maybe that, the court has the right to overturn a jury verdict, but it sets a terrible precedent.
Right, it does. And, that's the thing is it's
bad.
It's the jury's decision.
Right.
That's how the law works.
That's
the judge
how it works.
Overturn, but he's got to have reason and cause to. You can't just willy-nilly.
Right. And I mean, I'm not arguing that they didn't. I mean, I said that the whole trial. They rested their case, and I'm like, bye, Kel. That's not what I said.
Oh, bye, Kel.
Bye, Kel. Have a good day at work.
And I said, bye, Kel. Have a good day at work.
Oh, Spence, you talking to your therapist? I'm so happy. Whole thing. Can I get a summary? If not, I'll look it up and rewind the stream. Okay. Jenny, this is your bailiwick. Can you give Spins a summary of the Matthew Perry stuff?
Yeah, Matthew Perry. They've made arrests. They've arrested apparently so far a doctor, and it says arrests.
Multiple parties.
So I don't know how many there are, but they say a doctor and drug dealers. So, yeah. They're supposed to have a news conference at 1 p.m. Eastern. So, hey,
Oh,
Ween Baby.
Sorry, Spins.
Ween Baby said, I bet they had this ready in case she was found guilty.
Did
you need to go back to the beginning and check out.
Woo,
Go ahead,
the first
Kiki.
motion. I'm doing the same. I'm saying the same. Oh, with Matthew Perry? No, wait. Ween Baby, you're confusing me.
Wait, what?
She said, I bet I had this ready in case she was found guilty. And then she said, with Matthew Perry. What you mean, Ween Baby? Hi, Ween Baby. Hi. Hi.
Oh, the press conference for Matthew Perry. Yes, at 1:30.
At 1:30 or 1? Yes,
1 Eastern, sorry.
I set my alarm. Don't start. So Ween Baby, you got to go back and read. Either go back or scroll up in the chat. There's a link. Or one of the things. Did you hear? Were you here? Were you lurking and working when we did the motion to interview the jurors? Because girl.
Yeah, it's hairy. There's some juror misconduct shenanigans. Shenanigans. Big time.
It's not even really alleganiously because he brought receipts.
Yeah, I know. I mean, I'm saying allegedly just because.
Period.
Because I don't have said papers to show me and confirm that it's true, but I'm gonna say it's
really, really true.
Pretty true. And maybe one of the jurors allegedly had a whole flip phone in the jury room and was texting her brother with information.
And then Doofus was on Law and Crime posting and saying that his sister had a flip phone. Ween Baby. Here, wait. Let me go. Hold on.
To what kind of juror misconduct? We just told you.
Girl.
The other person, juror number 15, lied on her jury voir dire about DV situations.
So many times. Like multiple across what was it? Like 2003, 2004, and 2016?
Yeah, it was crazy.
So she had DV charges taken out against her. She had child abuse stuff taken out against her allegedly, but there's case numbers. And then 13 years later, she took out stuff against him, against her ex-husband. But on the jury questionnaire, when it said, have you had any kind of law enforcement interaction or whatever they say, she said no under perjury, under what's it called? Under threat of perjury. I'm going to say it that way. I know that's not right.
Oh, okay, because I don't know.
This all just came out, Ween Baby. Like, do you watch the docket on the X, the Twitter? I can't call it X. That's stupid.
Sorry. I know. I hate saying X.
It's the Twitter.
It's Twitter.
I do put the in front of everything because it makes my children crazy, and I'm Gen X, and I can do that.
Right.
The Facebook, the Instagram, the TikTok, and the Twitter. My child is probably cringing in his room right now. I don't think the same stuff happened. There has been other stuff, but it's not the same as what this is serious. This is serious. Like, I don't know. I need somebody to be ruling on this stuff with a quickness. Because her sentencing isn't until like October 22nd, and I'm gonna need an answer before then.
Right, I know.
I mean, I'm just not. Is it October?
That's a long time. That's like 2 months
That's
away.
a real long time. Let me look. Look at me knowing the things. It is October 22nd is the sentencing. I cannot wait that long.
I know, me either.
No more?
I'm wondering when, because it says that they want to hurry up and set a date for. Hopefully, we'll get some sort of a reply back.
There has to be something. You got to add an S to the end. It's the Targets and the Walmarts. And then it used to be the K mark. You had to put a K on it.
A K mark.
That was my grandma used to say, the K mark. I want to go to the K mark.
Okay. Oh my God.
All right. Argument. Let me read this thing. Argument. Whatever. Yeah. The state failed to rebut the defendant's clear evidence of self-defense. Florida courts have long recognized that the state bears the burden of disproving a prima facie case of self-defense. Wait a minute. I just got to the hoodie guy. Yeah.
Do what?
I was reading Ween Baby. She says, I just got to the hoodie guy posting that the jury had a verdict. Yeah, because his sister was texting from a flip phone.
Right.
I'm squirreling really bad today, but Margaret. Do you remember Montgomery Ward? Does anybody remember Montgomery Ward?
Yes.
Okay. I used to love the Montgomery Ward. And that was the very first credit card that I ever had, was the Montgomery Ward. So how about I go to M's house the other day and my girl has a whole Montgomery Ward, brand new, just came in the mail catalog on her table. What?
Oh, that's cute.
But it's brand new. No, you're not hearing me. It just came out. Where did they come from? They've been gone. Are they coming back?
It ain't new. It can't be new.
It is. It's brand new. Brand new. Just came in
No.
the mail. Delivered in the mail. Like, are they coming back? I need to know. I have questions. I love the
I don't
Montgomery
know.
Ward.
I mean, if they're coming back, then Radio Shack has to come back.
And Sears.
Sears and Roebuck.
Sears catalog. That Sears catalog, bro. We used to make our Christmas list off of that.
Mm-hmm.
Sit and go through the whole Sears catalog.
The wish list.
The wish list. Mark it. You used to mark it. Fold the pages.
Yeah.
Yeah. But
Dog hear it.
Look, I almost flipped out. I was like, where did that come from? She goes, it just came in the mail. I was like, no, it did not, ma'am. It did not. You pulled it out of some place that you hide all the things.
Mm.
It was on her table. It was
she's
brand new.
Cute. She's super cute.
She's so cute. Wee Baby said they've been back. Where they been? I ain't seen them. I need to know. I need a Montgomery Ward catalog on. It looked, I'm not going to lie, it looked kind of like a Finger Hut catalog.
Oh, really?
Yeah, but it was still Montgomery Ward. I mean, it was all Montgomery Ward. But like when I saw the name on the catalog, I like had a flashback.
Oh,
Like go into the Montgomery Ward. Like we had a huge Montgomery Ward. I didn't know. Y'all, I did not know. Y'all been holding out on me. I didn't know. I'm going to have to check it out. Service merchandise.
I didn't know either. I didn't know anything about it. I mean, about Montgomery Ward. And to be fair, like I don't know that I've ever I remember hearing about Montgomery Ward, but I don't remember us like having one really.
Oh yeah, we used to. Like I said, it was my first credit card. I thought I was the bomb. The bomb with my little Montgomery Ward credit card.
Oh, you're so cute.
Wore it out too. Wore it out. They didn't tell me. I mean, they don't. They need to teach that stuff. I don't know, but she got a whole catalog, and I tried to steal it. She's like, "Don't you take my Montgomery Ward." I was like, "I'm sorry. I'll put it back." Anyway,
I'll put it back.
put it back.
I'll be good.
She always charge y'all. Y'all don't understand. I'm like, "I'll be right back. I'm going to the bathroom." She goes, "Don't forget to put your quarter on the lid." Bam. She's trying to make bank off of people using her bathroom.
That's cute. Well, people make bank at Aldi with the whole daggone quarter. Why can't she?
She's like, "Don't," and she goes, "Actually, you've been really helpful today. It's only 15 cents." I'm like, "Look, I only got a quarter, so."
It's worth the 15. It's worth the what? Dime to
Yeah.
it's worth the dime to leave you a quarter.
I love their flare jeans because I was tall and skinny and only their jeans fit. I'm just telling you what, Montgomery Ward had all the things. You could get a whole lawnmower there. And some jeans. And some jewelry. You go over to the jewelry department.
So it was kind of like Walmart Supercenter before Walmart had a whole Supercenter.
Sears. It was like Sears.
Yeah.
It was like Sears. Actually, the catalog was very like Finger Hut, Sears, but it was it wasn't like a Sears and Roebuck catalog, like the big 2-inch one.
Mm-hmm.
Exactly, Margaret. A washer and dryer and some shoes for school.
Mm-hmm. See, that's how it was at Sears. You could get everything at Sears. You could go get a washer, dryer, refrigerator, stove.
I had a Sears credit card too.
Yeah, and then go over to the other side of the store and get your shoes and your blue jeans and your,
If anybody's listening, and I don't think Sears has a credit card anymore, but if you get that Sears credit card, y'all pay attention because that monthly minimum of $10, that's all well and good until your interest is more than that little $10 payment, and you'll never pay it. You'll never pay it off. Don't do it.
Don't do it.
That's the financial cafe part of the
financial cafe.
We're giving real life advice over here. Don't do it.
Yeah, right.
Don't get the credit card. Look, they come at you too. I told my children, like when you graduate high school, okay, they are going to come at you with all the things, all the credit cards. Don't you do it because I'm not bailing you out. I'm not bailing you out.
You kill me.
Right? That Sears washer and dryer was no joke. They were no joke. Look, Margaret still got her dryer.
Oh, cute.
They were no joke. Is it the Maytag? Is it the Maytag? Didn't they carry Maytag? Wasn't that Sears that carried Maytag? How do I know?
I'll tell you what, those old appliances from back then worked way better than today's appliances. And they lasted a whole lot longer too.
Oh, Kenmore. Yeah, Kenmore. That's right, Kenmore. Sears. Yeah, it was Kenmore. I think my grandma had a Kenmore sewing machine. Anyways. Did I tell you? Okay. Did I tell y'all that I got this little thing called it's like a game. It's like a card. It's not a game. It's like a card thing of cards. I think it's called Tales, like Tales.
What?
Tales. It's called Tales. I think that's what it's called. Anyways, it's all these cards, and there's groups of cards. It's like early life, midlife, late life, and they're questions. And I'm doing it with M. So you pull them out, and it's like, what would you tell your 10-year-old self?
That's cute.
Yeah, it's so cute. I love it. Anyways, I got sidetracked. Yeah, pay now. Yeah, buy now, pay later. That's why I said it made me think of Finger Hut. Anyways, all right. I'm sorry. Back to the crime part. The uncontroverted. See, I don't believe that. I think he made that up. The uncontroverted testimony of Ashley Benefield, the only eyewitness to the incident, also the person who shot the gun or the pew, establishes a prima facie case of self-defense under Florida law. Ms. Benefield's testimony detailed a series of escalating aggravated acts by Doug Benefield, culminating in a violent physical assault and a situation where she reasonably feared for her life. Ms. Benefield testified on September 27, 2020. She and her husband, Doug, were loading items into a U-Haul truck. Ashley had prearranged with Doug that her belongings would be loaded last for easy unloading. Upon inspecting the truck, Ashley noticed that the items were mixed together, contrary to their agreement. I mean, did they have a written agreement? Like, what do you mean an agreement? When she pointed this out, Doug became visibly upset, loudly stating, "It shouldn't be your stuff, my stuff, your house, my house." He then demanded that Ashley start acting like a wife. as as
Is
the
there
day
sorry, I do want is there like a list, a checklist for that?
I know.
I
Bye,
might have like
Dobby.
a
Love you.
I love you.
Um, as the day progressed, Doug's behavior became increasingly aggressive and threatening. Ashley attempted to avoid confrontation, tried to de escalate the situation by changing the subject and repeatedly suggesting that they finish for the day, saying she was tired. However, Doug completely disregarded her efforts and became more agitated. The situation escalated to physical confrontation on 3 separate occasions. 1. In the living room, Doug deliberately body checked Ashley, who says that, with his shoulder, catching her off guard and causing her to stumble and almost fall. During this incident, Doug was clearly hostile, mumbling under his breath and glaring at Ashley. 2. In the garage, after Ashley strongly suggested ending the day's work, Doug again body checked her. Did I mention who says that? Demonstrating a pattern of increasing physical aggression. 3. In the hallway, Doug intentionally and forcefully drove the corner of a box into Ashley's right hip area. He looked her directly in the eye while doing this, showing clear intent. The impact caused scratches and a burning sensation. Bro. After the third incident, Ashley, feeling frightened and desperate to prevent further aggression, apologized to Doug despite being the victim. Doug then continued to the garage with the box. The situation continued to deteriorate rapidly. Ooh, can I curse? Deteriorate rapidly. He began screaming at Ashley, yelling, "Shut the F up," and calling her names. He accused her of trying to make him leave and threateningly asserted, "I don't have to leave. I can stay and spend the night if I want to, because I'm your husband." Hmm. At that point, Ashley was terrified for her personal safety. In a desperate attempt to escape the volatile situation, she ran towards the front door in an attempt to leave the house, but was physically restrained by Doug, that's a whole lot of sentence, sir, who grabbed her hand and yanked her back. He maneuvered himself between her and the door, trapping her. With menace in his voice, he demanded, "Where the F do you think you're going?" Do you like the drama in my voice? In a moment of sheer desperation,
I do
Ashley
like the
blurted,
drama. I do
"You
like
love
the
it?"
drama a
Okay.
lot.
In a moment of sheer desperation, Ashley blurted out, "I'm done and you need to leave now."
Mm.
Doug's chilling response, "You can't effing leave me," was followed by an unprecedented act of violence. He struck Ashley on the side of the head. This was the first time in their relationship. Um, this was the first time in their relationship that Doug had actually hit her, making a terrifying escalation of his abuse. Panic stricken, Ashley ran to her room, the only place she thought she that might offer some protection. She grabbed her gun, her heart pounding with fear. As she did so, she heard the ominous sound of the door hitting the doorstop, signaling Doug forcefully entering the room. Wow, this is good stuff. The sight that greeted Ashley was nothing short of terrifying. Doug stood in the doorway, his face contorted with rage, red, with veins bulging in his neck, his eyes, which Ashley described as black. He uttered the chilling words, "You're effing done." In a in a desperate attempt to stop him, Ashley held the gun in front of her and yelled, "Stop." Instead of retreating, Doug assumed a fighting stance, bladed, crouching. Y'all, if y'all could see me right now, I just did a fighting like a kung fu thing.
Oh my
Um,
god.
Fighting stance, bladed, crouching, and making erratic, jerking motions with his arms and hands. Ashley thought Doug would leave when he saw the gun. To her horror, he did not. Miss Benefield was trapped in the bedroom with Doug between her and the only exit. In that
Yeah, we're
moment,
gonna go on a ride. We're gonna go on a drive and turn our audiobook on.
look, I could do it. In that moment, Ashley believed she was in imminent danger of death or great bodily harm. Of great bodily harm at the hands of Doug, as he was visibly enraged and had struck her on the side of her head just a moment before. As he lunged towards her, she began pulling the trigger in sheer terror. Even as she fired, Doug kept advancing, his determination to reach her seemingly unaffected by the gunshots. Ashley, in her panic, moved laterally, toward the side of her bedroom to get away from him. She described the entire ordeal as chaotic and terrifying. The confrontation ended when Doug's feet apparently slipped out from under him, his legs going up in the air as he fell backwards. Still gripped by fear, Ashley immediately ran next door to John Sant's house for help. When asked why she shot Doug, Ashley's response encapsulated the sheer terror of her experience. I was scared to death. I thought he was going to kill me. There was nowhere to go. I was trapped in my home. He wouldn't leave me. He wouldn't let me leave. The trauma of the event was evident as Ashley described what happened. Ms. Benefield's testimony established all elements necessary for a claim of self-defense. Critically, the state presented no evidence to rebut Mrs. Benefield's direct testimony that she acted in self-defense, nor was it able to diminish her testimony on cross-examination. The unrebutted direct testimony of Ms. Benefield demonstrated that due to the threatening conduct and actions of Doug Benefield, she reasonably feared for her life and believed that deadly force was necessary to prevent imminent great bodily injury or death. The unrebutted testimony also established that Doug had committed a forcible felony, i.e. false imprisonment. B. This is just B? Bro.
Oh, Lord.
Circumstantial evidence insufficient to overcome direct testimony. In Diaz v. State, the court held that when the defendant presents direct testimony of self-defense that is not rebutted by the state, only those inferences properly arising out of the state's testimony in chief can be considered to rebut the defendant's assertion of self-defense. The court stated under these circumstances, only these inferences properly arising out of the state's testimony in chief can be considered. Didn't he just say all this? To rebut the defendant's assertion of self-defense. In this posture, that evidence, circumstantial in its entirety, is woefully inadequate to rebut the direct testimony that the defendant committed homicide in self-defense. This principle was also applied in Mayo v. State, where the Florida Supreme Court reversed a conviction based upon the state's failure to rebut the defendant's claim of self-defense. The instant matter is analogous to Ferguson v. State. He's basically saying it's the same too, but analogous. Okay. When the court reversed a second-degree murder conviction. In Ferguson, the state had no witness to testify about the actual shooting incident and presented no evidence to contradict the defendant's claim of self-defense. The court held that under these circumstances, the defendant was entitled to a judgment of acquittal. How do you have analogous. I got you. Okay. How do you have somebody, a witness to self-defense, other than the person that pulled the trigger when the other person is dead?
Right?
So she's a viable witness because she was there, but there's no... Here, the state's evidence is similarly circumstantial and insufficient to rebut Ms. Benefield's direct testimony of self-defense. Critically, none of the state's witnesses had any direct or personal knowledge of what happened because she killed him in Ms. Benefield's home, and she sent her mama and the baby to the park on September 27th, 2020. Or her mama said, I'll take the baby to the park so there ain't nobody here.
See, that's kind of I'm wondering about that.
I think the mama, I have a whole lots of words and thoughts about that. The state's case relies entirely on circumstantial evidence and witnesses who were not present before or during the incident in question. The state's witnesses can be categorized as follows. 1. Background and purported motive witnesses. Tommy Benefield, Eva Benefield, Stephanie Murphy, she was not a good witness, Dr. Brad Broder, Dr. Jason Quintel, Detective Gilliam, and Detective Moreland. These witnesses provided no direct evidence about the events of September 27th and at best only offered testimony about background and history. 2. Crime scene technicians. Amanda Conlon and Megan Dvorak. These witnesses merely described the process and manner in which they collected items of evidence. They offered no testimony about the actual shooting or the events leading up to the shooting, as they were not there. 3. Responding officers. John Jones, Tyler Ackerman, and Dan Dickerman. These deputies and detectives described what they observed upon arriving at Miss Benefield's home after the incident. They laid the foundation for the admission of evidence, but provided no direct testimony about the shooting itself. Other witnesses. Deputy Tom Barrell described Ashley's appearance after the incident. Daniel Hausdorff, FDLE expert, discussed how the gun worked and the many different reasons for the absence of gunshot residue or stippling on the shirt. John Sant, the neighbor, described the 911 call. Alicia Byers, Ashley's mother, who never testified to any abuse. That's what gets me. Raz, that's what gets me. They had her on the stand. The state called her. She was like, I was at the park. But also then the defense questioned her and never, not once, asked her about witnessing anything. Anything. And I know, don't trust me that I know that people can abuse people and other people not know. But she lived with her away from him.
Right. She did.
Like, I don't understand why the defense didn't ask. I mean, clearly anyways, okay. 5. State medical examiner Dr. Russell Vega testified that Doug's injuries were consistent with Ashley's version of events. Importantly, as can be seen below, the testimony of the state medical examiner Dr. Russell Vega corroborates Ms. Benefield's account of the events rather than contradicting it. This further weakens the state's case and strengthens the defense claim of self-defense. Question. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor. Answer, yes. Question. Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing to his chest from the front? Answer, yes. Question. With respect to the leg, you've told us that the gun would have had to have. There's too many. That sentence is wrong. Would have had to have been lower than the leg to get the upward trajectory. Answer, yes. Although I would say that, lower is a relative term and legs can be put in various different positions. If we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. If the leg were horizontal, for example, then we might be talking about a position which is above the leg but pointing upwards to the head of the body, for example. Question. So let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might the injury be consistent with that given that scenario? Answer. It's possible. But is it? The state's reliance on purely circumstantial evidence is particularly problematic in light of Ms. Benefield's direct testimony of self-defense. As noted in Davis v. State, we must not lose sight of the basic proposition that one accused of a crime is presumed innocent until proven guilty beyond and to the exclusion of a reasonable doubt. It is the responsibility of the state to carry this burden. When the state relies upon purely circumstantial evidence to convict an accused, we have always required that such evidence must not only be consistent with defendant's guilt, but it must also be consistent with any reasonable hypothesis of innocence. Evidence which furnishes nothing stronger than a suspicion, even though it would tend to justify the suspicion that the defendant committed the crime, is not sufficient to sustain conviction. It is the actual exclusion of the hypothesis of innocence which clothes circumstantial evidence with the force of proof sufficient to convict. Circumstantial evidence which leaves uncertain several hypotheses, any one of which may be sound and some of which may be entirely consistent with innocence, is not adequate to sustain a verdict of guilt. Even though the circumstantial evidence is sufficient to suggest a probability of guilt, it is not thereby adequate to support a conviction, if it is likewise consistent with a reasonable hypothesis of innocence. In this case, the state's circumstantial evidence fails to meet this standard. The evidence presented is not consistent with Ms. Benefield's reasonable claim of self-defense, which constitutes a valid hypothesis of innocence. Moreover, the Florida Supreme Court has long held that circumstantial evidence is insufficient to overcome direct, unimpeached testimony. In Holton v. State, the court stated, the rule is that where competent, unimpeached, direct testimony is adduced tending to prove a fact, such testimony cannot be arbitrarily rejected and circumstantial evidence substituted as the basis for a verdict. However, we gave it to the jury and the jury said she was guilty. So this principle applies directly to the case at hand. Ms. Benefield's direct, unimpeached testimony of self-defense cannot be arbitrarily rejected in the favor of the state's circumstantial evidence, which at best suggests a suspicion, but fails to contradict or disprove Ms. Benefield's account of the events. Okay, so I'm trying to make this make sense in my head. So the state has the burden of proof. Ashley got up there and said, this is what happened, and she was a direct witness. They did not present any direct evidence to refute her accounting of what happened. Therefore, reasonable doubt, which I said all along. But the jury looked at it and saw it different. So, I don't know. I think it's a bad precedent to start overturning. Now, if you want to give her a new trial because of all that mess in that other motion, absolutely. Absolutely. I don't see how she doesn't get a new trial.
Right. I don't.
Based
on none of the every bit of the stuff that that first motion you read, that
all receipt after receipt after receipt after receipt.
Period. Pretty much.
In light of these, I mean, I understand what he's saying. Hey, P. Lola's mom, I understand what he's saying. And he's not technically wrong. But for the jury got it and found probable cause or found beyond a reasonable doubt. I mean, I don't know how, I'm not going to lie. I don't know how they got there. I don't think the state proved it.
Yeah.
But the fact is that we give it to the jury for that. So for me, again, I've said it all morning, the stronger argument is the first one. The interview and the jury.
Right. Same.
I mean, all this other stuff is just like, to me, it just clouds the first one. For me, I mean, I'd be like, look, because, and again, well, okay, motion of acquittal. I don't know if there's a 10-day requirement to file on that one. I have to look it up. In light of these principles and the nature of evidence presented, it is clear that the state's circumstantial evidence is woefully inadequate to rebut Miss Benefield's direct testimony of self-defense. The state has failed to present any evidence that directly contradicts Miss Benefield's account of the events, and the circumstantial evidence presented is insufficient as a matter of law to overcome her clear and unimpeached testimony of self-defense. I mean, he's not wrong. But it doesn't.
I don't know.
I mean, he's not okay. He's not incorrect. He's stating facts, but for the jury got it and found there was no reasonable doubt. So you can't just be running around willy-nilly reversing things because you don't like how it went. Now, do I think she should get a new trial if that stuff in that first motion is true? Absolutely. 150%.
Mm-hmm. I think so too. And I'm just wondering, like, I want to know when the judge is going to, like, schedule that.
I need him to get on it.
Like today.
Like, if you haven't seen this, Judge White, we know you're watching us, even though you pretend like you don't watch the YouTube. We know you do. And I'm going to need you to read this expeditiously and make a hearing so you can hear all these things. I need to see exhibits, like I need to see the deets. I mean, you can write the deets. I mean, he's got specifics. I mean, it's specific.
Very, yeah.
Like specific. And then that dude turned around, the hoodie guy turned around and deleted it, or somebody deleted the comments off of Law and Crime. Come on now.
Yeah.
Come on now.
Sketchy.
Because you know they ain't got no mods in there going, oh, that's an untruth. We gonna delete it. They don't delete nothing. You can hold troll up in there and they don't delete it.
Well, I'm wondering
y'all don't go
if
trolling.
It's not a situation, where the sister was like, he's probably like, oh, a long crime, waiting and watching, and she's probably like, you better not say nothing.
I'm not. Delete.
I didn't.
Except somebody already screenshotted it.
Allegedly.
P. Lola, I think I've seen you before. Do you watch I'm struggling with the name. Trial TV Live?
Hi, P. Lola's mom. Hi.
I've seen you before. I don't know if you've been in here. Hi. So glad you're here, but I have seen you before. Yeah, I need Judge White, sir, with utmost respect, sir. Yes, that's where I saw you, Aaron and Chris. Okay, cool. I'm so glad you're here. Thanks for coming. I knew I had seen you somewhere.
Hello and welcome.
Glad you're here. Okay. The uncontroverted evidence supports self-defense. As stated in Harris v. State, the legal effect of uncontradicted evidence is a question of law for the court. In Harris, the court reviewed the testimony of the only eyewitnesses to the killing, found it to be uncontradicted and unimpeached, and reversed the manslaughter conviction, finding as a matter of law that the homicide was justifiable as having been committed in self-defense. Yeah, we do too. That's why I like Trial TV Live, because they're small and they're nice. They're nice people. And it's not
absolutely 100%.
Similarly, in the present case, Ms. Benefield's testimony stands uncontradicted and unimpeached. The state failed to present any forensic evidence or eyewitness testimony to contradict or impeach Ms. Benefield's version of events. In fact, the medical examiner's testimony corroborated her account. I would say that one of the things that they did put on that I think refuted her story was the picture of her face the day of and then 3 days later.
Yeah.
Because if he open hand hit her, like, open hand hit her that hard,
Yeah.
she'd have been red. She'd have been
Mhm.
red.
Yeah.
And so, yeah, that's what. Yeah, yeah. This was a hard one. This was a hard one. Um, have you seen Pilola? I'm just going to shorten your name, Pilola. Pilola's mom. Have you seen all this stuff going on with it? Have you seen like the jury stuff, tampering stuff, um, and all the motions that were filed yesterday? Because it's crazy. It's crazy. Um, but even okay, so wait a minute. So P. Lola, you said for a long time I thought Ashley was guilty. The trial gave me reasonable doubt. There it is again. Even though it changed your mind a bit and leaned towards her being innocent, you still had reasonable doubt. So how they came to, because I was the same way. And I started out with wanting to support her because I tend to automatically support any victim of DVSA, any of that stuff. Automatically, because there's so many times that they're not believed. There's so many times that their abusers do cover things up. And so I tend to lean that way until otherwise, you know, convinced otherwise. Yeah, until evidence shows otherwise. But the evidence in this case, I mean, for me, I think they were both toxic. I think they were both toxic, and I think they fed off of each other. I think he was obsessed with her. I think she used that to get what she wanted. And at the end of the day, I think that he was abusive, and I think she was manipulative, and she messed with his mind, and he messed with her, and it was a whole bad situation. But that's just my personal opinion. And see, I think they changed the law in Florida. The law in Florida used to be that you had to be in the back corner of the furthest part of the house, farthest away from the door, in order to have self-defense. And the fact that she ran, I don't know what year, it was before 2020, I think. Let's see, how long have I been here? What are we, 2024? Yeah, it was before 2020. So, Shiraz, this case stressed me out so bad. Like, it had me twisted. And then, like, when I was listening to Jay and Bob, and Jay was so just sympathetic to her, and so was Bob. It was hard. It was hard.
It was definitely a difficult, a difficult case. Like, I wanted to believe her, and I'm not like it's not that I don't believe her. I just don't believe all of it. And I don't know that I believe that it got to the point where she had to
That's my problem.
shoot him and kill him.
I believe her. I believe that what happened. Maybe she melodramaticked it a little bit. But, I mean, like, the whole slap thing, I'm having a hard time with that because there was I've seen people open hand slapped. There was no evidence of that. But the fact that she ran to the back corner and that gun was readily available, for me, makes it seem like there might have been a plan.
Right. Yeah.
And I'm not saying that there was a plan, but what I'm saying is I can't not think that there might have been a plan.
Well, and that's kinda how I feel too about the whole, like, I wanna know how many times did grandma take the kiddo to the park?
She testified that they went every day before at dusk because it wasn't hot. And I mean, that tracks.
Okay.
That tracks. Everybody does that. Everybody does that. So I don't know. My point in all of this is saying that I had reasonable doubt, and I don't know. he's not in this motion. He's not wrong. The problem is that we have a juror system for a reason.
Mhm.
And if you start reversing jury verdicts, it sets a bad precedent.
Right.
It sets a bad precedent. So, P. Lola, my bigger problem is they had Mama on the stand. The state called her, which I did not understand because she did nothing to help their case. But
Right.
the defense crossed her. Why are we not asking her about the abuse? Why are we not asking her, was Ashley scared? Why are we not asking about, I mean, she took the tea set that she thought she was being poisoned and put it in the garage for like 2 weeks and then took it down to the police station.
Mm.
It doesn't make sense. It doesn't make sense.
That doesn't make sense to me either. Another thing that doesn't make sense to me is all her exhausted, they use the word exhaustive, what they say
I don't know which part you're talking about.
about the criminal complaint.
Oh, yeah.
All that stuff.
Yeah.
None of that was ever found to be true.
And for okay, so that stuff, it weighs for me, but it doesn't weigh strongly because I've seen way too many times where domestic DV victims are not believed, and there is legit stuff there. There is legit stuff there, and they're not believed. Or if you have an abuser who is a narcissist who can convince people, look at uh Micah Miller.
Yeah.
And her husband, and he's got a whole following of people in a church. Now they're starting to fall off now, but I mean, if you are a narcissist and you can convince somebody that you're, the cat's meow, they're not going to believe you.
Right.
If you don't have hard evidence. I mean, even Micah Miller had hard evidence. They found that tracker on her car.
Right.
So that part of it doesn't weigh as heavily, just because, I mean, I'm not gonna lie. I mean, Taylor was going at that detective, and saying he said things, this, that, and the other. And hey, Lee, oh Lord, I'm hungry. Thank you.
Hey, Lee.
I've been wanting. You know what I wanted this morning? You have got me on this whole. I want some McDonald's.
Oh.
I want some McDonald's breakfast. And I want the 1,500 calorie breakfast. I don't need a nutritionist. Don't talk to me. I want y'all. I've got to go to a nutritionist. Anyways, and so you've had me wanting this coffee. So I get up early this morning, right? And Manchild has taken not the girlfriend to work, and I was like, oh, I could order it, and he could pick it up on the way home. And so I checked Life 360, and he was on the road that's right next to our road. And I was like, dang it.
Oh,
I know. I might set an alarm tomorrow. I'll get up at like 6:30 and be like, look, listen, I need you to bring me a big breakfast and a nice coffee. Have you had the big breakfast? That thing is the bomb.
I have not, but I mean, it's got everything, like the
It's got
pancakes,
everything.
biscuits, gravy, all of it.
No gravy. But it is like your whole daily calorie for the day. I mean, I'm just saying. But
Right.
hear me out. I eat it in 2 parts. Like, I don't eat it all at once.
Oh, okay.
You and them dang McGriddles.
Oh my god, those are so good.
Do they make them now again? Somebody said, oh, it's the bagel thing that came back.
Yeah, the bagels are back, but the McGriddles, oh my god.
P. Lola, welcome to the cafe part of the Crime Cafe. We do talk about food here a lot. The other thing that I need is them stuffed everything bagel things.
Those are amazing from Dunkin'.
I need that. And I'm mad. I don't have the thing that you have.
The free donut on Wednesdays?
Yeah, I don't have that in my app, and I'm mad. I'm gonna log in with your zip code
Okay.
and be like, excuse me, Jenny gets different deals than I do, and I'm the one that told Jenny about the app.
You are, I know. It's only fair that you get the same
It is
deals.
only fair, is all I'm saying. Also, if anybody goes to McDonald's and sees a Hello Kitty collector cup, I will gladly pay you Tuesday if you will get me a Hello Kitty cup today.
Today.
I'm mad Karomi is not on the Hello Kitty cup. I think that's offensive. I think why does Hello Kitty get she gets all the love all the time. She needs to share the spotlight and let Buttercup, it's not Buttercup.
Mm.
It's butter something. And Karopi and Karomi, and I don't know why their names are so close. The frog and then
Yeah,
Karomi.
I don't know their name
That's
many
what I'm
names.
saying because Hello Kitty gets all the action.
Right.
She needs to stand aside for a minute.
Did you see the Ty Beanie Baby ones, though?
I did not.
Huh.
But
That was
also,
one of the collections, look like the Ty
yeah, I
Beanie
scanned
Babies.
right past it. I was looking for Hamburglar and the Grimace because that's the one I had when I was a kid.
Those are fun.
Twins, have we not had this conversation? I like Hello Kitty, but I like Karomi. Karomi's my girl.
Mm.
Because Karomi is me. That's my spirit cartoon. You got the Beanie Babies cup? She got the Beanie Babies cup. She didn't tell nobody.
Oh!
Morgana! I need to go to McDonald's. I can't drive. Jay, can we go to McDonald's? I need a cup. Morgana,
Hmm.
are they glass? Are they glass? I could see you being Hello Kitty, Morgana. I mean, Margaret. Absolutely. 150%. I love Hello Kitty, but she needs to spare the I could see you being what's the little biscuit buttercup, the friendly one that Karomi fights with. They're plastic, Jenny. I'm
See,
out.
that's what I thought. That's what
I'm
I thought because
out.
Morgana
That
or
is a farce. That
we
is
were
a
talking
farce.
yesterday. I was like, they're
That,
calling them cups. If they
that's
would have said
crap.
glasses, then I would have went for it. But I don't want plastic cups,
That's
and they're
crap.
smaller. They're smaller. No.
That's crap. And you have to hand wash them. I mean, I hand wash everything, but no.
Mm-mm.
No. Margaret, that stuff might be worth some money. When I see HK, I think Hell's Kitchen.
Yeah, me too. Me
I love
too.
me some Hell's Kitchen.
Poppy, get out of there. So QB,
Hey, I know we
I've
got
got
2
a
minutes.
well here though. I got a stream.
Cinnamon roll, cinnamon roll, cinnamon roll. Yes, that's her. Sorry.
I've got a stream scheduled for 1 PM.
Okay. Do you want me to read really fast? Stop talking.
No, I don't want you to stop talking.
Okay. I can read
You
really
can
fast. I mean, there's still 9 pages, but we'll see. A lot of it's probably certificate of service.
Okay.
Okay. All right, y'all don't talk to me no more.
Let's do this.
I got it. Similarly, in the present case, Miss Benefield's testimony, if I'm too fast, y'all let me know, stands uncontradicted and impeached. The state failed to present any forensic evidence or eyewitness testimony to contradict or impeach Miss Benefield's version of events. In fact, the medical examiner's testimony corroborated her account. I was going too fast for my own self. The principle that uncontradicted testimony cannot be arbitrarily disregarded has been consistently upheld in Florida courts. In Brandon v. State, where the evidence is uncontradicted, it is not impeached or in any way, either directly or indirectly, and is not opposed to the probabilities, nor in its nature surprising or suspicious. There is no reason for denying its conclusiveness. The principle applies directly to the case at hand. Ms. Benefield's testimony is uncontradicted, non-impeached, and is consistent with physical evidence presented by the state. D. Evidence is legally insufficient to overcome the presumption of innocence. As reiterated in Garmis v. State, a motion for a directed verdict of acquittal should be granted where it is apparent that no legally sufficient evidence has been submitted on which a jury could legally find a verdict of guilty. But they did. In this case, given the uncontroverted evidence of self-defense presented by Ms. Benefield and the state's failure to present any evidence that rebuts this claim, there is no legally sufficient evidence on which a jury could find, but they did, could find Ms. Benefield guilty beyond a reasonable doubt. But they did. The Florida Supreme Court in Holton v. State emphasized that while the jury are the sole judges, of the credibility of the witnesses and the weight of the evidence, they are not the sole judges of its sufficiency. The legal effect of competent evidence, which is not impeached, discredited, or controverted, is a question of law for the court. In light of these principles and the evidence presented at trial, it is clear that the state has failed to meet its burden of proving beyond a reasonable doubt that Ms. Benefield did not act in self-defense. But they did. E. Evidence is insufficient when viewed in the light most favorable to the state. Bro. P. Lola's, there is a press conference that is talking about Matthew Perry and the arrests that have been made.
Yeah, that's what I'm on.
Do you have it on? Okay,
I've got a feed, but I don't know if they're going to be on time or not. But looks like I'm seeing now there have been 5 arrests, including 2 doctors. So I keep seeing more and more information. So yeah.
Spins, I can see you totally loving Kuropi. I love Kuropi, but Kuromi is my spirit cartoon. Because she's sweet and kind, but a little bit not. Sorry, I'm trying to find where I was. I scrolled down. I think I was on E. Yes. Okay. Do you want to cut the feed and go to the other one, Jenny, to be ready? And we can pick this up. I mean, honestly, for me, it's not my stream.
Well, I mean, I honestly didn't look through this 20-page document just because
I think it's the same stuff that he threw at the judge during the trial, and I don't see it.
I don't see any merit trying to disqualify the judge whenever he already tried to get the judge to stand down during the trial. And
so do you want to jump over to Matthew Perry and then we can come back and tell us?
Yeah, probably.
Okay.
Yeah. Because I want to see I can't. Yeah, I want to see what's what. So, hold on a second though. I've got a link.
Okay.
Hold on a minute.
Hold on. Wait a minute. Let me put some bass in it. Oh, sorry. I got it.
The link to the Matthew Perry stream?
The link. I got the link. Let me put it in the chat.
Yeah, if you guys want to run over there, it's where I'm headed, and the stream will start at 1:00 in about 5 minutes. So thank you, QB.
Love you.
But I'm glad that you guys joined us over here today for all of this juror misconduct shenanigans.
$1 on the wall. She's getting a new trial.
The one with the phone?
Bro, the girl with the DV.
And the DV. Man.
Mm-mm.
The one that lied in the voir dire.
A whole lie and a whole crap. They both. Oh,
and a whole flip phone. And a whole flip phone.
A whole flip phone. And who said it? Was it Patricia that was saying, "Look, the only flip phone, the only way that a burner phone works is if you both got burner phones, bro."
Right.
ain't wrong.
That brothers are going to be sent up there in front of the judge, and he's going to be like, "Did you get a text from your sister?" Yeah, P. Lola's mom. God.
Come with us, P. Lola. Come with us. We're going to go over and see Matthew Perry.
Yeah, we're going to go see Matthew Perry.
For Tellis. Well, Jenny will be.
5 arrests so far that we know of. So anyway,
I need names. I need names.
Well, I think there might be a potential name, but I don't know if they haven't confirmed it. And it's one of the like a doctor. Hi, Marty. Thank you for covering this case. I just found your channel and subscribed. Thank you, Marty.
Thank you.
Thank you very much.
We're heading over to a press conference, and you can come with us. There's a link in chat if you want to come with us.
Yeah. Hopefully their press conference is on time, and we'll see. I've got a feed. It's not an actual feed. It's looks like CBS has got something up and ready. But we'll see if they're on time. So, but we'll see you over there. I would love for you guys to come and hang out.
You can't portal people yet, can you?
No.
Oh, that's rude.
I know. But
I feel like you should be able to portal people. I don't even know if you could portal people into your own thing.
Are you going to continue this case coverage after Chandler Bing's presser? So depending on how long the press release is, or the press conference, I'm not sure if we'll be back. I mean, when we come back today later, it's going to be the rest of the Robert Tellis trial. Is it Robert?
Yes.
Tellis trial, yeah. P. Lola's mom, she's talking about how you can like raid, like somehow or another, there's something YouTubers can set up to where whenever you leave here, it would automatically put you into the next stream, but I don't have that feature yet.
It's a beta. It's in beta, and not everybody got it, and apparently Jenny didn't get it. So,
all right,
Marty. Can I say something? I know you want to go.
Yeah,
Marty. So we read all the motions today. I can guarantee you, if there's a hearing or something, keep your notifications on, because I can guarantee you Jenny's gonna follow it.
Yeah, I will.
You can raid in YouTube, but not everybody. It's called portaling, like a portal potty. Anyways, okay. Love y'all. I'll see y'all over in the other one. I'm gonna jump down so Jenny can do all the things. Love you.
Yeah. Love you, QB. Thanks for reading. Thanks for being my voice today, man.
Yes, love you, mean it. Bye.
All right. So we are gonna go. I'm gonna go. Go. And please join us over here, and make sure to hit the thumbs up before you leave, and join. Make sure to subscribe, click the thumbs up, all the things. All right. I'm gonna scooch on over there. My brain is wrapped around Matthew Perry right now, obviously. So, but thank you again, QB, for helping me out today and being the voice, because I got a scratchy sore throat today. All right. See you momentarily. I love you guys. # replay in the comment section down below. Bye.